Um, welcome on this day. The time now is 7 minutes past 10. We have the quorum to start, but looks like it's also a quorum for even decisions, as we have this two-pronged approach. Let me take this opportunity to welcome all of you members. And today, all of you seem to be on the virtual. You've left the chair alone on this chair at M46. So I want to welcome you from the virtual platform. I see you've also been joined on that virtual today by the public protector. I want to recognize and welcome her, as well as I see also her team led by Advocate Mbofu, also on virtual, to welcome the evidence leaders, Advocates Bauer and Mayosi, who remain where they were from day one. Members of the media who are with us, our entire support staff present, as well as the members of the public who continue to participate in this inquiry in their own way. Thank you very much. Welcome. Today is the 3rd of April, 2023. We continue with our work of the inquiry. And today is supposed to be day 7 of listening to testimony of Advocate Mkhwebane. And I want to therefore start and recap with all of you where we left on Friday. I would have summarized and concluded the meeting with the fact that we said we had the challenge of one of the 3 risks that we identified that would have been brought to the fore, having materialized. And that risk is the one of the legal fees. We indicated on Friday, and we still do, that it is not the work of this committee to be dealing with that. Ours is a very focused mandate of conducting an inquiry as part of the National Assembly extension as a committee. We would have indicated that the relevant role players would have to find a way to mitigate that risk. And I would have shared with you that we have a very clear commitment to conclude what we have started, that this inquiry is not going to be left hanging, and more so I will have indicated that that would be unfair to the person who has an alleged misconduct and incompetence on a name, who is here on the basis of us testing fitness to hold office of that person. So, and that position still stands. I think early on, even last year, I was very clear in indicating that this inquiry cannot have a middle wish. It has 2 possible outcomes. One, being an outcome that the PP is exonerated from all the issues that were tabled as part of the motion, or two, that this committee makes findings on those charges and therefore makes a recommendation to the NA, and then everything else follows in that regard. And those two possible outcomes remain the prospects of this inquiry. The middle wish of in between, again.
Let's see what Richard's got to say.
I should have had the laptop.
We're going to ask Ms. Van Minen to mute. You are now in the inquiry. The conference of your parties is gone, in case you think you're still there.
I was muted, Chair. My laptop tells me I was muted, so I'm not sure what's going on here.
You have to be muted indeed, because the chair is on the platform. Thank you very much. You've just disturbed me a bit there, Honorable Van Minen. And so as we meet today, just to indicate to everybody that as I indicated Friday, that we're going to ensure that the relevant role players take up the issue. The report is that that work is seriously underway. I'm not in a position to give any details on that. It's not our space. And we hope that in a very urgent time, space, would be in a position to indicate what are the outcomes of such endeavors to ensure that we continue as we start today with our work. So that's what I want to firstly put forward. And therefore, in that regard, it's going to be important that we then use the time whilst that work is happening to ensure that there's continuity in the work that we do. We would have finished part A of the very comprehensive statement by the public protector. And in that, we would have concluded to the CR17 and the charge relating to the issues around the unit, Kodan, so-called rogue, and so on. And all of those general points that would have been made. And therefore today, it's supposed to be the start of as we get into day 7, because part of what I also indicated on Friday was that the public protector was initially would have been given 6 days. As a chair, I would then have extended that as the practicality shows in front of us that we still have to go through the CX, Friede, and those HR issues, that her days would have been extended to 10 days, meaning this being day 7, from today until Thursday, all of that time given to her to make the 10 days. They would have indicated on Friday, the legal team, that since there's been a stoppage of financial support, that they do not have further instructions And so before I proceed with what I intend us to do was that it's not what you're going to have to we're supposed today to start part B of the statement. Having said everything else that I've said, to invite the public protector and her legal team to indicate if they are ready to resume on part B.
Good morning, Chairperson. Good morning.
Over to you, Public Protector. I was hoping that you'll be here, but I see you are in the air. Welcome.
Thank you, Chairperson. Remember, Chairperson, the Friday discussions about the issue of the resources. So I was told there won't be any resources from the 1st of April. So I'm here with Advocate Mpofu is not here with the legal team, Chairperson. He only joined just to make clarifications to the committee members in case there are any. As explained on Friday, that the letter which was written by Deputy Public Protector Galeka, so it has placed me in a position where the legal team, or I couldn't give further instruction because the legal team was hoping that by the weekend you will be giving them a solution to the problem. Remember, Chairperson, the letter of the 1st of March was written to me, was copied to the Chairperson of the Section 194 Committee, Chairperson of the Justice Portfolio Committee, and to the Speaker. So I think the cry from the office was that all of you, maybe you could assist. So I would indicate that my presence here today, as I have explained, was that I couldn't, well, you asked on Friday whether, I mean, since the 1st, remember I had to prepare, go to court for the perjury matter. I was on sick leave. But then at the end of the day, Chairperson, I am here not proceeding. And remember, Chairperson, we haven't dealt with all the issues in part A of my statement, which is, you've mentioned CX and issues relating to Friday and issues relating to the legal issues. So, or the so-called
HR issues.
The HR issues are in part B of the statement, Chairperson. So I was just referring to what part A of the statement relates to. So I think that's the position which I am here on, and Advocate Mpofu can clarify if you need him to clarify, but he's not here to represent me, because he said, in fact, he said he'll join, though he has another consultation, I think in the earlier, later part of this morning. So I think, as I indicated as well, Chairperson, that you know how clear, well, the clarity of the Constitutional Court judgment about being represented and the trial proceeding with full representation. So I don't know, Chairperson, when you say we are proceeding, and on Friday this is what we have discussed, and if the legal team are indicating that they've got other commitments, I couldn't give issue here. further instruction unless then I receive something which would say in writing, here are the resources, and indeed then I can proceed with them to proceed with the inquiry. So as I said, even originally, Chairperson, that I'm here indeed accounting to Parliament, and this is part of my accounting to Parliament. And normally my accounting to Parliament also includes then this process, which you correctly mentioned that I'm here for you to determine my fitness. And unfortunately, Chairperson, you know, we've mentioned several times that the expansion of the mandate or the inquiry to the original motion brought all this. And if we could only have focused on the panel's outcome, possibly we would have finished. And I think we've explained even to the office, because originally it was 35 days, which was the estimation from the legal team. But unfortunately, then that went beyond what was proposed or planned for, or it was something which was beyond everybody's control. So that's that, Chairperson. I don't know whether you'd want Advocate Mpofu to add, or I'll just hand back to you if you've got any questions or clarifications from me.
No, thank you for that presentation, Advocate Mkhwebane. Maybe just two things to say. That firstly, to repeat what I said at the beginning, that there's urgent and serious work that is, as we sit here now, that is underway to follow up and make true the commitment that we made on Friday, that we don't want this inquiry to stop in the middle, and that is continuing. So, and as I speak now, we don't necessarily have what the outcome of that and the details of that. So I repeat that point, that so that it must be clear that there would have been work done even over the weekend to ensure that we achieve the continuation of this inquiry. So I just want to maintain that point, and maybe during the course of the day we'll get updates and briefings. But as of now, what I can say is that there are processes and things that have been put in motion in that regard. Then the second point is in relation to, I think if I get you correct, you are saying Advocate Mpofu is logged in, is present in the inquiry, but he is not on brief from you. Is that a correct understanding on my side?
That's correct, Chairperson.
Thank you, PP. And therefore, that being the case, I think it's only fair that we don't burden him with explaining anything or clarities, because we are in a formal process as we do things. We appreciate that for his commitment, even if he has other demands that are coming his way. Of course, you will know that today until Thursday and next week has already been programmed, and there is that kind of an expectation that if that risk would not have materialized, he would have been here. So it's only to be fair and appreciate that he is demonstrating further that he wants to continue being your legal team, but I wouldn't want to burden him with any clarities at this stage, and that being the case, I would then want to proceed therefore to the next point.
Maybe to clarify, Chairperson, he was just here as a courtesy, not to say to proceed or anything. It was just a courtesy from him. So unless then you wouldn't want him to clarify, but it was just for the courtesy since he has other commitments.
Yeah, no, I hear you. I hear you, PP. The issue about Friday, I think I would have summarized at the end and gave a ruling. If there are any issues you want to raise or clarities, they would not relate on what we discussed on Friday. And you have already spoken and indicated that you are ready to continue accounting to this body. But there's therefore the issue of you not having the legal support, which we accept. So my intention is not to be all over the place and raise other issues. I think I'm quite covered with your explanation, which is consistent with what would have been said on Friday. There's just nothing new in that. So I do insist that I wouldn't want us to abuse him simply because he's here. So if you're okay with that, I want to proceed to the next point. Thank you. Colleagues, and honorable members, then I just want to address you on this point that Honorable Hanif Hendricks. He probably did not raise that hand by himself. There might be a technical problem there. He's not, because I think we're conversing with the PP, so it's clear that there is no audio problem, or he's disconnected. Honorable Olomisa, do you want to take his place? Honorable Olomisa, I see your hand.
Yes, thank you very much, Chair. Good morning to everybody. I think, Chair, you may have to consider postponing this hearing today until you have until the public protector and the parliament, or rather acting public protector and parliament, have possibly found a solution to this problem. Because we have a constitutional court decision which says the public protector must have a legal representative. So I would suggest that you postpone this and then you iron out these problems which have just cropped up. But then at the same time, we know that we are dealing here with a situation where another court found that the public protector was wrongly suspended. How I wish she can go and work, go back and work, whilst we continue to do this hearing or conduct this hearing. Thank you.
Thank you, Honorable Olamisa. You've decided to make a proposal even before I start. I will assist you in that regard, but let me give a hand to Honorable Hendricks and Honorable Mautwe. Thereafter, I'm going to proceed to the next point I was intending to do. Honorable
Thank you.
Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I was very impressed with how you summarized where we stand now. You made it quite clear that we have two options, that the public protector be exonerated. Secondly, that the committee has certain findings which you present to the National Assembly. Maybe you have covered my position, Al-Jamaah's position, that there's a third option, and that there is a settlement in this matter, so that we can bring proceedings to an end. I also want to state that there is a problem with the resources, and the General has explained justification for trying to postpone this hearing. I don't think we should postpone the hearing, that we should continue. The public protector is here to account. The committee has heard all the evidence to support the DA motion. We have heard the public protector has submitted extensive affidavits responding to the DA allegations. It is my view the committee has enough evidence to proceed to make a finding. And however, we need to level the playing fields, seeing that the public protector doesn't have legal resources. Maybe this committee must also then let their legal resources stand down, and let this committee then proceed with its work. So I'd like to make that submission. Thank you very much, Honorable Chair.
Thank you, Honorable Hendricks. Honorable Mautwe.
Thank you, Chair, and greetings to everyone. Chair, I'm a bit confused when you move from this point of the PP not having legal representation, and then you say you want to make the next point. So it makes it difficult for us to engage, because you don't know what your next point is. But when I look at the agenda for today, Chair, there's only one item, which is the hearing. And then that PP must appear before the committee. So perhaps before you even go any further, let's hear your, because we want to engage on this matter. I mean, this is a very serious legal matter. But you prohibit us from engaging by saying you want to move to the next point without having concluded the first point, which is, in my view, the primary issue for this meeting. So maybe clarify us on that one first before you go any further. And Chair, you like to speak for all of us. I don't know why you find it comfortable to say there won't be a need for clarity from Advocate Dalimbo. You don't know if we were going to need clarity from him. So you are speaking for yourself. You're not speaking for the committee, because you have not engaged on this matter. So I find it very problematic, Chair. So maybe let's allow you to go to your next point with advocating both on the platform, so that whatever you say and you want to engage and you want to get clarity from advocating both, he's around. We don't have to log off and log in again or go call for him. You just had PP now saying that advocating both has got the consultation. So he might be consumed the whole day if you release him now. And by the time we want to come in and have clarity from him, he might not be available. So I think let's leave him on a platform and get to your next point so that we can engage on this matter, because we really need to engage on the fact that PP does not have a legal representation. I thank you, Chair.
Thank you, Honorable Mautwe. Maybe before I go to my next point, just to quickly respond on the two issues raised by the members. Firstly, to start with Honorable Hendricks, I fully comprehend what you have put forward, Honorable Hendricks, and indeed it's a sound proposition which is consistent with what we would have indicated on Friday and today, except on one issue, the mandate of this committee. As part of Section 194, it is a committee set up by the National Assembly to do work and the veracity of the charges and the motion itself. And it's clear in our rules what journey we need to travel until we get to the NA. And so, as I indicated earlier, in terms of those two possible outcomes, this committee does not have any other mandate and would not engage in any other issue. You would be correct if you speak about issues of settlement, but they are outside of the jurisdiction and the mandate of this committee. We don't engage in those issues and would not even attempt to make that as a possible outcome. Our work is cut out, very clear what we need to do. We would not do something that, because the National Assembly recommends appointment, the president appoints, the National Assembly emphatically recommends removal, the president removes. So if there are going to be issues of settlement, they are outside of the National Assembly. National Assembly never doesn't get involved in those. So I wouldn't even want to entertain that as a third possible outcome. We've got two possible outcomes, and I hope that clarity would help. And then to come to Honorable Maotwe, I am with you. You wouldn't have followed what I indicated, that there are no clarities needed from Advocate Mpofu following the summary and the way forward of Friday. If you were with us on Friday, you would have understood why I make such a determination. And we're not going to go back to Friday. We're here today on Monday, day 7 of the inquiry. And so I want to be as clear as that on that issue.
We can't hear you.
You can't hear me? Honorable Olomisa?
No, we can hear you. I think the problem is there with Mr. Olomisa's side. We can hear you clearly.
Just reposition yourself, Honorable Olomisa, so that you are able to follow us. Now, let me leave that, having clarified those two issues, because I think Honorable Hendricks makes an emphasis on the point that would have even made on Friday, that this inquiry has to be concluded and everything must be done to ensure that where there's a gap, the shortcoming that is there, that materialized risk must be attended to. I've already indicated the work that is being done by the relevant role players in that regard. That as I speak here today, I'm not in a position to say this is the outcome of the work they have done, but I've been informed about the work taking place, and as a chair, I'm sharing that with you. So the next point I was going to, honorable members, that's where I wanted your attention before the hands were raised, was that we indicated before that we're not going to waste any time. We're going to make sure that we do the work of this committee, understanding and accepting that there is a particular dilemma and shortcoming in the legal team of the PP continuing to get to the next 3 charges as indicated, which is CX Frede and all HR issues. So that the next point I'm working with you towards, members, is that today, us not being in a position to confirm that the legal fees have been attended to, it will not be a day that will be wasted. We're going to have to utilize this time to ensure that we do work. And the work that we're going to do, honorable members, is in the context that if Advocate Mkhwebane's team would have concluded on Thursday, because by today, they have already concluded on the issues of the CR17, as well as the unit issues and those general issues that we concluded on Friday. At the point when the evidence leaders start their work, they would indicate, as they have always done even before with the other witnesses, that they would take the members, the committee, through certain aspects of the work that they'll be going through. So you need to remember that evidence leaders are the extension of this committee. They've been so designed to assist the committee to unpack all the issues and to assist them in terms of how to follow the entire process. And so what I'm putting to you today is that, and this is something we would have done when we go to cross-examination or them leading questions, because they don't do cross-examination, members would do cross-examination and the questions in terms of the Concord decision, is to ask the evidence leaders that on the matters that we have concluded, that I've indicated, the PP is not going to be asked any questions today or tomorrow, but the work that must happen is to invite the evidence leaders to do what they would in any case do when they take the platform, because that would also help us to save time when we get to that point, that the evidence leaders on the two matters concluded take the committee in terms of what approach and issues that they would traverse. This is the next point that I'm going into. And this next point is also to help us save time, because when that support comes, it means that it will come as having not lost time or created unnecessary delays. And therefore, that's where I'm going to, honorable members. And perhaps at this point, I am going to invite the evidence leaders, but before that, I see a hand of the public protector.
Oh, Chairperson. Okay.
Go ahead, I can hear you. I can hear you.
Chairperson, I think I've mentioned that I am here. I am alone. I don't have my legal representation. And Chairperson, as this committee, you are obliged to act according to what the Constitutional Court has said, firstly. Secondly, Chairperson, you've got directives which are very clear on what process to be followed. On Friday, you refused, or you refused that the evidence leaders should cross-examine before I finish my evidence. So this is not part, I mean, how do I then sit here without my legal team? In essence, whatever they are going to be saying, the evidence leaders, hence I have a legal team assisting me, Chairperson, to note all the issues which they are supposed to be noting,
so that when I continue presenting my evidence, they also know what is the issues which the evidence leaders will be saying. So I don't think that would be proper and that will be fair, Chairperson, if you do that, because that will be violating your own directives. So, and it will be a totally unfair process for you to continue doing that. And Chairperson, since the beginning of this hearing, and actually I indicated during my opening statement that since the beginning of this process, I've always guided and suggested to the speaker and the refusal to listen, but then we take it to court, the court finds in our favor, again, wasting time, wasting resources. So I think for your sake and for the sake of the committee and parliament, that would be better if the chairperson can make sure that we work and we get the resources so that we can proceed with the legal team. The process cannot continue with the legal team. And I wonder why the legal team will even entertain this contrary to the directives themselves. And what fairness is there if this matter proceed and they present and they summarize? What's the Chairperson? I don't think you would want to expose yourself, actually personally as a Chairperson, to that particular situation, because this is not the proper way to go. But then it's in your hands. I've put it on record that whatever you are doing, it's very much unfair. Actually, what would be fair for you is all hands on deck to find the resources so that we can proceed in a proper manner. Remember, your directives are saying it should be fair, reasonable, without delay. So I think everyone is listening, whoever can avail the resources, that can be done. And I even propose that Parliament is also spending a lot of resources to pay the very same evidence leaders. They are not public servants. You are paying them. And I think there was a question from Honorable Sukres about the resources paid to my legal team. They are also paid from the fiscus, which should also be declared, and everyone must know how much they are paid. And wherever they get, you get the resources for them, get the resources for me, so that this process can be finished without delay. So that's all from my side. Thanks. I think the best way is to postpone, Chairperson, so that we all go all out there and get the resources.
Thank you, Advocate Mkhwebane. Honorable Heron.
Thank you, Chair. Good morning. Until the Public Protector spoke, I wasn't clear yet on where we were at this morning, because Advocate Mpofu is apparently on the platform. But now I hear directly from the Public Protector that she is going to be here alone. And so I think it raises concerns for me if we're going to proceed with any part of this process with the Public Protector unrepresented. Even if the evidence leaders are only going to set out or traverse what they propose to do, we've seen throughout the hearing how both the evidence leader and Advocate Mpofu on behalf of the Public Protector have challenged some of the stuff that has been said as part of argument or laying the basis of the evidence that's going to be led. So I can't see how we can proceed with the Public Protector unrepresented. And I don't understand what happened over the weekend in trying to resolve this. I don't understand the committee's role in trying to resolve it, but the Public Protector is entitled to legal representation throughout the proceedings, and we can't continue. I don't see that we can continue without her being represented. Thank you.
Thank you, Honorable Heron. Honorable Zungula.
Thank you, Chair. Greetings to bullies, all of the honorable members, including the PP. Chair, I want to agree with Honorable Heron in the sense that there is a court order to the effect that the PP is entitled to legal representation throughout the entire process, not parts of the process, but the entire process. Now, I would urge, Chair, that we do things correctly. We would not want a situation whereby the committee works for the longest time ever, but gets some of the things wrong. And after getting the things wrong, the report of the committee gets to be reviewed by technicality, in the sense that there were parts of the inquiry which the public protector did not have legal representation, whereas the court order is very clear on the public protector must have legal representation at all times. Remember, Chair, that the public protector did not invite this inquiry. It is an inquiry that has been brought by process of parliament. And, you know, so we can't expect a public protector to fund, you know, the legal team from her own pocket. At the same time, we've seen how in the Zondo Commission of Inquiry, when there were no funds, processes were made and plans were made to avail funds so that the inquiry can get to reach its conclusion. Now, I would urge Chairperson that let us do things right. If the office of the public protector through the deputy public protector is stated that there is no funds, I would advise that there should be an engagement between yourself and the speaker. Maybe the speaker speaks to Treasury to say, this is the situation that is there. The public protector is entitled to legal representation of their own choice. Now, in this case, there's no funds, there's no resources availed to fund the legal representation of the public protector. Therefore, the Treasury must intervene, avail funds, so that when the process is done, we are 100% certain, Chair, that there is no prospect of the report being overturned because of a mere technicality. So I would propose, Chair, that let us not, you know, push to proceed with the inquiry for the sake of time. Let us understand that there are other elements that we need to consider, and particularly this one when it comes to the legal representation of the public protector. So I wanted to put that proposal, Chair, that perhaps yourself, you engage the speaker on behalf of Parliament or behalf of the National Assembly, approaches National Treasury and to avail funds only after we are sure, we are certain that when the inquiry proceeds, there is no, the rights of the public protector or anyone for that matter have not been trampled on. You'll recall, Chair, that as the evidence leaders are going to do whatever work that they are doing now, there will be part of the work of the evidence leaders that the public protector might not be comfortable with, or might not agree with, or might want to rebut. Now, in the absence of the legal representation, she can't do that. That is why, Chair, I want to make that proposal. Thank you.
Thank you, Honorable Zongola. Honorable Mautwe.
Yeah, thank you, Chair. Now that you've presented your next point, which is what I said earlier on, that we're unable to engage because we don't know what your next point is. So your next point says we proceed with the meeting. It will be wrong, Chairperson, and it must be noted like that. The rules and the Constitutional Court is clear that PP must be represented throughout the proceedings. It doesn't say for other matters or when you deal with other matters. It can be upon the committee to decide, no, for this matter, PP doesn't need legal representative. We can continue on our own without her. It's wrong. And the evidence leaders actually must say that themselves. And the legal team of Parliament must actually say it to this committee. They are the one who are supposed to defend Parliament, by the way. Because if we continue, Chair, we are bothering on unfairness of this whole process, which started last year, which has already spent lots of public money, only to be overturned by court to say no. But there were sections where the PP was not represented, and the rule is that she must be represented. So I don't know what is the rush for. I don't know who's putting you under pressure, because it's not me and you or her who caused this mess. It is the acting public protector with her letter that there's no funds. So let's go get funds. But the bottom line is, Chair, we cannot continue without PP's representation. And the legal team of Parliament should actually come and tell us that. We should not be fighting with you. So I think they're not doing their job, because we shouldn't be arguing this matter. They should be the one to say, no, the rules are clear. Without public protesters representation, you can't continue. So I don't know why we are still even debating this matter, Chair. But to continue, it will be really very wrong. It will be unlawful. It will be illegal. It will be unfair for the PP. So let's not continue. Let's not even think about continuing, Chair. Thank you.
We can't hear, Chairperson.
Honorable Lagude, you can't hear.
You're audible now.
Chair, no, Chair, after I spoke, there was a complete silence. So I don't know if you were speaking after I spoke, but we could not hear anything until Honorable Lagude. Yes.
Oh, all right, let me repeat. Thank you for alerting me to that. I don't know what the challenge is. Can you hear me now?
Yes, I can hear you now.
Yes, we can hear you, Chair.
Chair, you are silent again. We can't hear anything.
Honorable Maneli.
Yes, now we can hear you. When you say Honorable Maneli, that's the first statement you just said. That's the only thing we had.
Thank you, Chair. I hope I was not the one who's not hearing you. And I hope I'm also heard at this point.
No, there's something wrong, Chair,
Can I-
on your side. Honorable Maneli, can we hear Chair? Because we can't hear him. He comes and goes.
No, I can't hear the chair. So I wanted to check whether it's on my side or that I proceed if I'm audible, but I can't hear the chair.
Yeah, Nama can hear. So the last time we heard him was actually was when he said Honorable Tlakude, and then he went and kept quiet again. But
it seems that there's a problem now. It seems there's a problem.
Chair, I propose
We can't hear you.
sort out your
But this
audio.
admin, can you control your admin? They can't just willy-nilly mute us without any instruction from you. What informs them to mute us? We're raising a point that we can't hear the chair, and then we're muted. What is this?
You're not audible, Chairperson.
Good morning, honorable members. We seem to be having a challenge with the sound from the venue. So we'll take 3 minutes to sort that out, and then we'll resume again.
No, thank you.
But who's muting us when we speak here without any instruction from the chair? That's out of order, man. Yes.
I can hear you, Chair.
Okay. Thank you. I was inviting you to make your contributions, followed by Honorable Dlagude. Over to you, Honorable Maneli.
Chair, I think with that sound problem, the ancestors were speaking. It's a signal. You must check it properly.
Please mute. Uskadla ancestors mo. Please mute. Over to you, Honorable Maneli.
Thank you, Honorable Chair. Chair, I just wanted to make just a few points. The first being that, first, let's accept the report you have given, which report indicates that as matters would have been raised, those matters are receiving attention. However, as we meet, we are not in a position to confirm the final resolution of those matters, in particular the matter we've just dealt with, Chair, which regards the PP. I thought it's important that we support you on that, that the report is clear. It's still an unfinished work. However, on the second point, Chair, I also want to suggest that indeed, given that we have not completed hearing the evidence of the public protector on the remaining issues that still need to be dealt with, that probably it may be premature to look at landscaping from the side of the evidence leaders. Because also in that landscaping, there may be issues that need clarity, which will be matters that may also come later in the arguments. And if that happens in the absence of this matter being resolved, indeed it may, in my view, Chair, border on this part that we may have not heard that the public, the legal representatives are here on the platform as a matter of courtesy, which in this case I would say to hear what the way forward is, because at this point there's no legal brief on them to proceed. And that proceeding means to also take notes, even when evidence leaders are on the platform as part of the preparation later on. I therefore want to suggest, Chair, that this may be different in a situation where the committee from time to time would have convened as a committee, and when it convenes as a committee for matters that are focused on the committee, would have released, in most instances, both the evidence leaders and the PP and the legal team to leave members to engage on matters that relates to members in the committee itself, as opposed to those that have come as invited to this committee, whether in the form of evidence leaders or in the form of the PP with the legal team to come and account before the committee. So I want to suggest, Chair, that if the meeting is not really just the committee to look at possible options going forward, that we do not proceed in that way. Probably use this period to do the follow-ups on the interventions. As you would have said, we may get feedback whether midday or any other day from now, because the matter is receiving attention. Maybe from the side of the PP, for me, what could have been important from the point of the time, because I hear your point well there about the time, it's a concern we've all had, is that once the resource issue could be resolved, whether we can then look at the time, because there was already a booking, like you say, of being available throughout the process, and whether that availability then could not be brought forward as a way of responding to that report that may come. Because I take it that in the main, it is just about the confirmation that resources would be made available as opposed to proceeding to incur costs and later on learned that there will be no resources that will be made available, and it gets to border also on irregular or even unauthorized expenditure that may have been incurred in this case. So that's really what I would want to put, Chair, before you. So this point I'm making may have been made, but with the connection, maybe I may have lost some of the inputs that have been made, or the clarity that you may have given. But if it's not the committee alone, I would suggest still that we do not proceed as such, but use the day to chase progress on the matter. I submit. Thank you.
Thank you, Honorable Maneli. Honorable Dlagude. Off the platform. Okay. Honorable Dlagude is not on the platform. Maybe honorable members, at this point, this is how we're going to do this. Firstly, what we're dealing with here is that both the CR17 as well as the unit issues is evidence that was placed here. So that's evidence on record. Let me start there. Whatever that I was inviting the evidence leaders to do was never going to be any new evidence started by them. So there's evidence that is on record that in the last 6 days that we listened to. Two, it remains an important point that one, there's an issue of procedural fairness and doing things within the reasonable time. That's always the issues that we have got to balance. And I would have determined that there's no intention for us to waste any time going forward, even as we await the outcome of those interventions on finances. And as you know, evidence leaders have got a specific task that we designed it to be like that, which is a task of ensuring that the committee and the members in particular are assisted in some of the very complex and difficult issues. And I think as a chair, I'm going to take that responsibility to ensure that that happens. So thirdly, so what is going to happen, having listened to all of you with the inputs that you have made, I think all of you seem to suggest that, and this is the determination I want to make, that perhaps at this point, we can step off the inquiry, and I'm going to ask that we take a 15-minute tea break. When we come back, we'll come back into a committee session. Those who wish to continue being there can do, because our meetings are transparent and public. So when we come back from break in that committee meeting, I will take you through what we'll be doing in that committee meeting, which has stepped off from inquiry, because the issues that we need to attend to are important to be attended to. So at that point, I'm going to ask that to take a 15-minute break. We'll be back at past. Thank you. Welcome back, colleagues. As I indicated before break, that we would step off from continuing with the inquiry, and we'll get into a committee session. And in this committee session, I am going to invite Advocate Bauer to take the members through the parts that are indicated are important that we traverse so that we save time when the actual inquiry resumes. This committee meeting is still open to everybody as we have transparent meetings in the National Assembly. So everybody is welcomed. There's no one barred from being present and participating in this meeting. Thank you. Over to you, Advocate Bauer.
Good morning, Chair. Good morning to the members and the public. There is a context in which this is being done, which maybe requires a bit of a precursor to me going into the issues that we will traverse, and so that there is some understanding of where it's coming from. There are essentially terms of reference and directives that guide the work of the committee and the role of the evidence leaders. The directives were drafted for purposes of regulating the shall we call it, the procedures within their inquiry, and the terms of reference exists as have been drafted under the aegis of the National Assembly. The role of the evidence leaders is contemplated to be effectively threefold. The one of presenting the evidence, which is there, putting questions to the public protector or other witnesses, and to assist in empowering the committee to assess the merits of the evidence in line with its mandates. And what I understand the chair to be asking us to do is to deal with the latter part of it. Ultimately, the assessment of evidence.
Are you safe? Yeah. Okay. All right. Okay. I need a choice. Lydia.
Honorable Suela, can you mute Honorable Suela, please? Thank you. Go ahead, Advocate Bauer.
So ultimately, the task of assessing the evidence falls on the committee. And the evidence leaders is to assist the committee in doing that. Now, there are effectively three forms of evidence before the committee. The obvious one is the oral evidence, which has been led and which you've been hearing when we convene. The documentary evidence, which is the evidence which we've put up, which becomes evidence once it's been led before the committee. And the other evidence, which one finds informed under Directive 3.6.4 of the rules of the committee, of the directives, which says affidavits and evidence presented by the evidence leaders which form part of court records may be regarded as being sufficient for its purposes as presented without oral evidence being led in relation thereto. And the members will recall that as evidence leaders, we upfront didn't take you through the court records when we led other witnesses, because we had indicated we would do so at the time when the public protector came to give evidence, and following on that, we would ask questions arising from that. Now, the presentation today obviously will then lead on to whatever questions we would later ask the evidence, the public protector when the inquiry reconvenes. But the purpose of this is to take the court records, putting it into the legal context, and taking the members through effectively where that falls within the CR 17 matter or issue. You also know that under paragraph 7.2 of the directives, the committee may consider affidavits and evidence that have been filed in other proceedings and before other bodies provided that the evidence leaders and or the public protector shall be permitted to put forward evidence and submissions contextualizing the affidavits or evidence in question, which is relevant to the motion. Now, we haven't had anything other than court proceedings before the inquiry, save that last week the public protector sought to put an affidavit before the committee, which had been before the state capture inquiry, and that would fall under paragraph 7.2. And members who had either been on board last week or had listened to the recordings afterwards would be aware of how we dealt with that. So it's not falling into that category. It's under 3.6.4. And what I'm going to deal with today is solely going to relate to the matter of CR 17, and it's in the context of charge 11. And it might make sense if I read what charge 11 says to you. 11.1 states that it deals with the failure intentionally or in a grossly negligent manner to manage the internal capacity and resources of management staff, investigators, and outreach officers in the Office of the Public Protector effectively and efficiently. Charge 11.2 states for failing intentionally or in a grossly negligent manner to prevent fruitless, wasteful, and unauthorized public expenditure and legal costs. And 11.3 states failing intentionally or in a grossly negligent manner to conduct the investigations and or make decisions in a manner that ensures the independent and impartial conduct of investigations. And charge 4 is by deliberately seeking to avoid making findings against or directing remedial action in respect of certain public
On a
officials.
point of order, Chairperson.
Just a pause, Advocate Bauer. Honorable Zungula.
Yes, my apologies, Chair. I did not want to speak without being recognized, but I raised my hand a couple minutes ago. So I don't know whether you saw it, but I wanted to raise a point of order, Chairperson. Firstly, can I proceed, Chair? Are you fine with me raising a point of order?
Yes, what's your point of order?
Firstly, Chairperson, the evidence leaders, in fact, you said we are going to proceed in we are going to call it a committee meeting, not an inquiry. Now, any legal advice in the past in a committee meeting, we used to get it from the parliamentary legal services, not the evidence leaders. The evidence leaders should not in any way present whatever without the legal representation of the public protector. Because in the context of this inquiry, the evidence leaders, someone can say they play a role of being somewhat the prosecution team, and the legal representation of the TP is like the defense. Now, to have the prosecutors present whatever in the absence of the defense, that does not seem to be fair and procedural from my view. The second issue, Chairperson, is that I don't recall a meeting where we said as the members, we want the evidence leaders to present whatever. So I would not know if you are saying the evidence leaders are going to assist the committee. We don't have such a resolution as a committee to say the evidence leaders must come to the committee and assist us. There's no such thing. So whatever, if you want as a chairperson to receive whatever assistance from the legal, from the evidence leaders, you can have that arrangement on your own, but not under the guise of a committee. So I wanted to raise that, chairperson, that it is grossly unfair that the evidence leaders are going to proceed in this manner without the defense of the public protector, because even the issues Ms. Bauer is talking about now are the issues that are relating to the inquiry. The issues that she's going to deal with are issues in which the legal representation of the public protector can want to disagree with or can want to challenge. Now, in the absence of the legal representation, how can they challenge whereas they're not here now? And when the members are listening, that whatever she's presenting will inform or influence how the members view whatever they need to view regarding the cases Therefore, it cannot be that she's going to be allowed to proceed without the legal representation of the defense or of the public protector. So I want to appeal to you, Chair. Let us do things correctly. Let us not, invent, things on the way. Let us not open ourselves to a situation whereby the entire proceedings can be challenged because of such, mistakes or such things. If you want, if the members want any form of assistance, just like we've done in the previous matters, the parliamentary legal support system is here to provide that assistance. The evidence leaders must only engage the committee in the presence of the PP's legal representation. And I think that is what even them, as as professionals in the legal field, would want to operate. In fact, they know this much better than us, that they can only take up such space in the presence of their colleagues, not take up space and address matters in the absence of their colleagues. That is not fair, Chairperson. So I wanted to raise that point. Thank you.
Thank you, Honorable Zungula. I just want to indicate immediately that you have raised a point of order, and that point of order is not upheld for the following reasons. One, there's no legal advice that we're being given here to start with, as I explained before the break what we're trying to do. Secondly, this is a constitutional inquisitorial process, not an adversarial process that must be likened to courts, including prosecutors and defenders. And further, I've explained not once, many a times, that when we started as this committee, the issue of evidence leaders was our own invention as part of the committee to assist the committee. That's the role that they play. And this is a committee session that I've declared so that we get that assistance to empower the members. And I've indicated that what they're dealing with is something that has already been put on the record as evidence. So I want us to proceed with Advocate Bauer. Over to you, Advocate Bauer.
Chairperson.
Yes, Public Protector.
Yes, I see I'm being muted, but I've raised the hand even before Honorable Zungula. I was not logged in because before the break you said it's a committee session, and I was just watching on YouTube. I see now you handing over to the evidence leaders who are not members of the committee. I excuse myself because several times you were excusing my legal team, myself, and the evidence leaders. So I'm still saying, Chairperson, this is not the proper process to proceed with. It's unfair. It impedes and violate my rights, because whatever they are going to be saying in this process, which, Chairperson, I've been following as well, how the very same mainstream media, which is continuously smearing my name, saying this week it will be a cross-examination, some secrets and whatever. So the evidence leader, how do you play to that? Ethically, as a legal practitioner yourself, how do you allow yourself to just proceed with this process? It's inquisitorial, but it operates within the constitutional principles. So I just joined to just clarify that to you, Chairperson. This is illegal and unlawful and unethical, and possibly I'll exercise my right as well to lodge a complaint against the evidence leaders to the Legal Practice Council, because you cannot behave like this as evidence leaders. And this is a committee session, but I'm saying this will violate my right out there, because my legal team is not here to object and to do anything. So this process is unlawful, Chairperson. And as you said, that this is a committee session, and I thought you are excusing me as well, because there's nothing more to talk about because this is for the committee member. I'm just putting this on record, and I don't think this is a fair process, because she's addressing now the evidence I've presented without my legal team, irrespective of that. And you made a ruling on Friday, Chairperson. Now you are somersaulting on your decision because she wanted to cross-examine and you refused her to do that. Now you want her to speak and speak. And Chairperson, this, I will be recording it, and as well yourself, because you are also allowing this to be blown out of proportion. We're talking about my integrity and my credibility here. And this has always been your Maria Tham or your Karen Moore just reporting negatively and against what evidence I'm presenting. But then I've placed it on record, and I think this is the evidence I will be utilizing to go forward. Thank you, Chairperson. And I mean, the very same letter of the first Yagacaleka, we should, all of us, especially the committee and the parliament, should have addressed her to say, or try to, all of us were quiet since the first. Well, for me, there was nothing I could do because I'm not controlling the funds. I'm suspended. But that letter collapsed this whole thing because it should have been stopped at the beginning, Chairperson. So I don't understand what's the intention of the evidence leaders. This is recorded, and I'm going to deal with that. And what Honorable Maneli said.
Thank you, Public Protector. Thank you. I think you have covered the points. Let me respond quickly on that. Firstly, no. Honorable Zungula, I'm on the platform. I didn't even give you an opportunity to speak. You didn't even raise your hand. Please. Let me just respond to this. I think the Public Protector has covered what she wanted to say. And this is what I want to say. Firstly, this is a public meeting. Nobody is barred from joining it. I've made that point even before and after the break. This is a committee session that we're engaged in. In fact,
but Chairperson,
no, you can't do that. No,
the
you can't do
evidence
that.
leaders are addressing you. You can't say it's a public.
No, you can't do that.
We can
Please,
get
please.
in, but why are they participating? No, Chairperson.
I did not give you a platform.
No, Chairperson, you can't treat me like that.
There was no interruption.
No, no, you are misunderstanding what I'm saying. I know it's a public platform, but then no, I actually was not even finished when you
allow me to speak. You're not going to interject whilst I'm speaking.
But then it was
you are not going to interject whilst I'm speaking.
They can't participate without my legal team.
Please mute her.
Okay,
please mute her. You're not going to do that.
Me?
Yes, you're not going to do that. This is the parliamentary session. It's unacceptable that you just come in when I've allowed you to speak until you've covered the points that you want to make. And I'm now responding to the issues that you
and I was clarifying you.
Don't respond, please. I'm on the platform. The issue I'm making here is that in response to what you have raised, that firstly, nobody is barred from participating. Nobody was chased away from joining this committee session, but this is a committee session which is meant for the participation of the members. Okay, I've allowed you to make the points of orders just as a courtesy, but this is a committee meeting. And so whilst you can join and listen in, the discussion now is meant for the members of this committee. That's the first thing I want to say. And secondly, I don't think you have to determine what we do or not do as a committee that you are now accounting to as part of this inquiry. And so I don't think that I hear what you're saying. I don't think that it will therefore stop us from proceeding in this manner. I've explained there that there's been an evidence that was placed for 6 days, and today we're going to just assist the committee unpacking the issues for it to be ready, because this is something we would have done when the evidence leaders start asking questions to you, but today they are not asking those questions. We're going to make sure that we don't waste that time when we start that process. And that's what we're doing. so that there's nothing that somebody is going to be prejudiced out of this process. And I was trying to address when you came in to the issues that were raised by Honorable Zungula in saying, because I was in the middle of doing that, in saying that it's not, the issues that he is raising are not correct in the manner that he has put them. And therefore I wanted to proceed and continue with this matter. I did not, I thought it was something else that you wanted to raise, hence I recognize your hand. I probably should not have done that. This being the committee meeting and the discussion is that of the members. I hope that is now understood.
Can I be excused,
Thank you.
Chairperson? Can I be excused?
Well, if you select to do that, that's fine.
Okay, thank you.
Thank you. Honorable Mautwe.
Yeah, no, thank you very much, Chair. Chair, I'm not sure what you are asking Advocate Bawa to do exactly, because she's an evidence leader. So she's leading evidence of what? Because before we went to the 15 minutes break, you said you were stepping off the inquiry. Now, she should have packed her bags and left, because you said the next sitting now is the committee sitting, the members. She's not a member of this committee. She is the evidence leader. She leads evidence in an inquiry. So outside the inquiry, what exactly is she doing? So I think that's the first thing. Advocate Bell must pack her bags and go. And Chair, if you want us to have a committee meeting, explain to us what are we meeting for. I pointed to you earlier that the agenda that you circulated has got only one item, which is the hearing of the PP. Now, in the absence of the hearing of the PP, there's nothing else. So I don't even understand why we as members who are still in this platform, we should all log off, because you adjourned the meeting yourself when you said we're stepping out of the inquiry. And we thought that you are bringing something else that which is new, that you wanted us as a committee members to deliberate on. But you are continuing with the inquiry, Chair. In the true sense, you are continuing. And it's unfair, it's unlawful. You can't do that. Even earlier on when I spoke, I said to you, why don't you get legal services of parliament to come and guide us what needs to happen? You have not done that, unless you will say that's what they are saying. And it will actually make sense, because that's what you get, which is what makes parliament to lose cases everywhere. That's the kind of services you get of people who should actually be objective and say to you that, Chair, you cannot continue in the absence of a legal representation. So, Chair, this thing is illegal that you're doing. Let's just stop here. Advocate Bauer must pack your bags and go. This meeting must be adjourned until such time that the PP has got representation, because it's a reality that we are constituted to discuss the inquiry. We are part of the inquiry. Now, what else are we going to be discussing outside of the inquiry? We're not friends. We're not discussing soccer here. Or not discussing the 10th anniversary of the EFF, which is coming on the 29th of July. We're discussing the inquiry. It's wrong, Chairperson. Please, just get guidance from us as your members. Even your own member told you that you cannot continue. So I don't know what else you want us to do, but it's wrong, Chair. Please. We are literally begging you, Chairperson, that let's not do this. Thank you.
Thank you, Honorable Mautwe. The evidence leaders have been directed to come and make the presentation. And I want to go to them now. I'm not taking second bites, Honorable Zungula. Honorable Olomisa, I see your hand. Honorable Olomisa.
Thank you. Chairperson, I think there is a disagreement amongst the members of the committee. And I think it would be better that you consult us before you come to a conclusion of this nature. For instance, Honorable Maute has just said the evidence leaders are only supposed to brief the session, plenary session, Why do you want us now to change the rules?
Are you done, Honorable Olomisa?
I'm done, sir.
Thank you, Honorable Olomisa. Advocate Bauer, please continue.
Chairperson.
On a point of order, Chairperson, I've raised a question. You need to respond to us. Don't treat us like a schoolboys. Respond to what we have raised. How?
Can I address you, Chair?
Are you done, Honorable Olomisa?
I say to you, sir, just respond to what we have raised. You can't say she must continue whilst we are questioning her presence and the presentation under the present circumstances. Don't bully us.
Chairperson, can I address you?
Thank you, Honorable Zongola, and thereafter I'll make a ruling.
Thank you, Chair. The first one, Chair, I raised a point of order. You said I must raise my hand. Now, when I'm raising my hand, you are saying you are not going to allow me to have a second bite. I find that it is.
I hope it's not on the same point. I hope it's not on the same point. Go ahead.
Chairperson, I'm trying to address you. You are interrupting me. The first point I want to address, Chairperson, is that when the PP advocate Mkhwebane was speaking, you interrupted her. Now, I would plead with you, Chairperson, to allow a person to speak, whether you agree with her or you don't agree with her, because you can't want to silence a person when addressing a point or when she's clarifying a point that you have not understood in the context in which she wants. So that's the first thing I wanted to address. The second issue, Chairperson, is that you are saying this is the committee of the members. It is now the members that are engaging in this particular meeting. It's no longer in Paris, where you would expect the evidence leaders and the defense and the legal representation of the public protector. Now, the evidence leaders are not members of this committee. So how are you wanting them to actually address the committee? You are saying you want them to empower us. We've never said we want them to empower us. Secondly, in their empowerment, as you say, there will be issues whereby the legal representation of the PP may want to object. How can they object if they are not here? So I want to plead with you, Chairperson, let us do things the right way. We would not have any issues if you wanted the parliamentary legal services to empower us or to, to raise issues to us. That is in line with how the committee has done things in the past. We've never had, the evidence leaders being part of a committee, empowering members. It's even worse, Chairperson, that has not even come from the members. It's not members who said, let us request the evidence leaders to empower us of anything. So it is you alone as a chairperson. So I want to caution you, Chairperson, please do things the right way. And when we're raising these issues, as we Chairperson, we are just wanting things to be done correctly, so that if anyone were to report or challenge this report that will come out of this process, we know that we've done everything by the book and we've not opened ourselves to a risk of, izinto, and you find that in the process we risk turning the entire time into wasteful expenditure because we did not follow the law, we did not follow even the directives of this committee. The last thing, Chairperson, as we generally saying, when we're raising issues, we would humbly ask that you listen to what we are raising, because if there's 3 members, all 3 are saying there must be, the evidence leaders must not present. It cannot be that alone you are going to make a determination that they must proceed, because if this is a committee of parliament, and in a committee of parliament, like we've done in the past, it is consensus, and that consensus comes from the members who are, expressing their views. It can't be that all 3 members are saying one thing when you want now to somewhat impose your own view against the majority of the members that have spoken. I would understand if the other members from the other parties spoke and in their input, they are saying, let us proceed. Now, I would understand that when you are doing your summary, you are doing the summary based on the majority view. But in this particular case, the majority view from the members who have spoken is that let us not proceed with the evidence leaders. If there's a need for any empowerment, Stella, the Parliament Legal Services. So please, Chair, let us do things correctly and please don't fight with us because we're also not fighting with you. We are pleading with you, but let us follow what the Constitution says, the law says, and the directives of this committee. I thank you.
Thank you, Honorable Hendricks.
Thank you, Honorable Chair. Honorable Chair, our view is you're doing things the right way. Secondly, that you are not treating us as schoolboys. I have earlier on indicated that the proceedings must continue. We must not waste extra minute. However, you did not take my advice that we must level the playing fields and that the evidence, seeing that the public protector has no legal representation, that the evidence leaders should be excused. And if there are any issues that you need help on as a chairman, the parliamentary legal team is there. They are not just here to swear people in. They are here to assist Parliament. And Chair, this has been a very expensive motion for the country. We cannot allow matters to drag on until the term of office of the public protector ends. Al-Jamaa as a party, there is sufficient evidence that we've heard from both sides. In fact, too much and a lot of unnecessary evidence where we are able to make a decision whether the public protector must be exonerated or make findings. You rejected our suggestion that another option is a settlement in this particular matter, so we can close this. We cannot bankrupt a Section 9 committee. We cannot bankrupt the country with these kinds of proceedings. So I just want to confirm again that we're very happy the way you are conducting this hearing so far. Thank you very much.
Thank you, Honorable Hendricks. Honorable Maneli.
Thank you, Honorable Chair. Honorable Chair, just on the first point of clarity, is that before we took the break, because the break came as a result of
You've gone quiet. You're breaking up. Is it still there? Honorable Maneli. You need to reposition
in the
yourself.
inquiry.
No.
What we are now convened in, you can take a
Honorable Maneli.
Be here now, Chair.
Please reposition yourself and start again because we missed everything you said.
Can you hear me now, Chair?
Yes.
Yes, Chair, I was just saying that in the first session, which was the inquiry itself, you've listened to the views expressed, and surely that informed your ruling. That we take a break, but when we reconvene, it is not us proceeding with the inquiry in the absence of the public protector and the legal team.
Honorable Maneli, I don't know what's
but
wrong.
We proceed as it then taken through. So I thought it's important that I have not moved. I'm still in the same space. I've not moved.
We can't hear you, Honorable Maneli.
There's a connectivity problem.
Honorable Maneli, we can't hear
Maybe
you.
proceed, Chair, if you can hear then. I've made the point that we're now convened as a committee, we should proceed as such and be briefed. The point, Chair, about the legal side of things, I thought when the evidence leaders clarified the role and they referred that they are dealing with the third part in their role, not to lead evidence or anything, but help the committee in that way. What you may need to, what needs to be tested, Chair, so that we deal with anything that may come back for the committee, is for a confirmation that there's nothing illegal that is taking place, and therefore the evidence leaders are not appropriating any responsibility that they do not have in terms of their appointment. I thank you, Chair. Let's proceed.
Thank you. Thank you, Honorable Maneli. I see you're coming back, Honorable Olomisa. Other members, you also free to come in if you want to comment on this. Honorable Olomisa.
Thank you, Chair. What I would suggest we do, let us call in the parliamentary legal advisors, as it is normally the case when we have our own meetings. And also the legal advisors would also respond to the call that the evidence leaders do not have to come back or brief us currently without the presence of the legal advisors representing the public protector. And public protector's office under the leadership of Kalega has actually caused us to be in this quagmire. It is her in writing that she's stopping this process by refusing to fund the legal advisors as instructed by the Concord. So what I would suggest we do, we need to adjourn for now and then let the state law, the parliamentary legal advisors to brief the committee as to whether what the process you are following now is within the bounds of the law. Thank you.
Thank you, Honorable Olomisa. We are guided here by our own rules, the terms of reference we created, the directives that we have, and all of those are not prohibiting us from doing what we're doing. And in fact, Honorable Maneli would have clarified that part of the role of the evidence leaders is not just to lead evidence or cross-examine. The essential and the main role of them was meant from the very conception of this to assist the committee in unpacking the issues that we're dealing with. So we don't need a legal advice in understanding that. It's been our role. It's going to be difficult that for everything that we must do, there must be an off-ramp for a legal advice. It doesn't assist the work of this committee and the pace of it going forward. And we've always been consistent where there are matters that are very murky and not clear. We've sought that legal advice and we've operated in that way in a number of occasions. But it can't be that for every decision, for every intervention that is made, there has to be a legal advice on that. We are empowered as these members as part of our constitutional role to do what we're doing. So I hear your point, but I don't think that it suggests that we need to be seeking legal advice in proceeding in a manner of being briefed by evidence leaders who are an extension of this committee by the very creation of this committee. Honorable Sukas and Honorable Dlagode. Honorable Sukas, you're muted.
Good morning, Chair. I don't know if you called my name or Honorable Dlakude's name. I'm sorry.
Your name?
Oh, okay. Honorable Chair, good morning to you and to everybody at M46. and everyone that's listening in on the committee. Chair, I think it would be helpful, and I think you have already touched on that now. You've already touched on it now in your reply. There is a concern around the public protector being without her legal representative. I think it is not, as a committee, certainly, it is our duty to ensure that we abide by the terms that were set. And I think we have done that consistently. However, what I think is important possibly for all of us as members, so that the fears of members be allayed, that the process not be compromised in any way, and that the rights of the public protector by us as the committee not being violated, is that there be a re-emphasis of the points that you have made. And for that to be made in this meeting by the legal advisors, as well, the legal advisor of Parliament. And the reason for this is a parliamentary process, as you have said now. It is also, we know, a novel process. I think we established that. A novel process in the sense that we are bound by the terms of our constitutional duty as members to ensure that we complete the process within the stipulated time. We are also bound by our constitutional duty to ensure that whatever evidence we have heard, that evidence be properly engaged with. There's been a mountain of evidence that has been given in the last couple of days. And it is important for us, certainly for me, it is important that I be enabled and empowered to deal with that evidence, to properly scrutinize that evidence, to understand it properly. So I think because of the concern that is currently in the meeting, that it would be helpful that the 2 points that you've made, the one around this is a committee meeting of Parliament, and secondly, that the issue around what that means, and that it does not mean that it violates the rights of the public protector, but that it actually insists upon our duty to ensure that we do our job and we do it properly. It's a bit long what I've said, Chair, but I think I fully understand your point when you are saying what you've said. But I think the concern, the technical concern around legal representation within the context of the committee possibly is difficult for members to grasp. Last week we had, Chair, personally, I want to put this forward. Last week, I think what was emphasized for me is our duty, our constitutional duty. And I think all members need to remember that. We have a constitutional duty in this process. And part of that constitutional duty is the enablement and empowerment for us to be able to deal with what we have heard. So I think it would be helpful, possibly, Chair, if legal services can come in here to reestablish the context of which you have spoken when you replied to Honorable the General. Thank you, Chair.
Thank you, Honorable Sukas. Honorable Diana.
Honorable Chair, you recognized me.
Oh, my apologies. You're right. Honorable Lagood and then Honorable Diana.
Thank you very much, Honorable Chair. Good morning to you and my colleagues and everyone on the platform and in M46. Honorable Chairperson, you adjourned the meeting so that when we resume, it will be a committee meeting. And we have been addressed by the evidence leaders, and we were assured, because the evidence leaders, like you have summed it nicely, that they are an extension of the committee. So if there is nothing illegal of what is currently happening, then we may proceed as a committee. I want to agree with Honorable Maneli on that one. We may proceed with the briefing by the evidence leaders who are trying their level best to empower us as the committee so that we may conclude this process. I know, Honorable Chair, that we are empowered by the Constitution, by the rules of the House, and also by the resolution of the House which established this committee. So the expectation of the nation out there and all of us is for this committee to conclude its work within the legal framework, of course. So, Honorable Chair, if there is any doubt of what is happening currently in this meeting, then there will be a need for the parliamentary legal services. But I heard you correctly, and I know that what we are currently doing now with the evidence leaders, there is nothing wrong about it. But if members are uncomfortable about the proceedings now, then the parliamentary legal services may come in to brief us. But from my side, I'm very comfortable with what is currently happening, because what the evidence leaders are currently doing, they are empowering us as members of this committee so that we may see this work of the committee through to the next level. Thank you very much, Honorable.
Thank you, Honorable Lagude. Honorable Denner.
Thank you, Chair, and good morning to everyone. Chair, I think the previous two colleagues actually said what I'm about to say, but I just want to reiterate, Chair, we have a constitutional duty to see this process through. And we also have a duty towards the Constitution and towards the PP that we have to do everything in a procedurally and substantively fair manner. But Chair, the PP herself said that she has been listening to what we've been saying. She has been watching the proceedings, and she even said that she has been recording it. So she's not been excluded from these proceedings. It's been been done in a very transparent manner. So I see no problem with the fact that the evidence leaders are briefing us. So we, in turn, understand the evidence that's been put before us, so we can do our constitutional duty. So I think we should proceed, Chair, and that's just in short my contribution. Thank you, Chair.
Thank you, Honorable Denner. I see you want a second bite, Honorable Sukas. You have learned from the other members.
Yeah, Chair. It's only Chair to say that if there's any doubt, or if there was a lack of clarity on what everything that I've said, I'm fully supporting what you have laid out. And I really want, Chair, that the whole issue around our constitutional duty and what we are bound to as a committee, Chair, to be re-emphasized. It is my genuine concern, Chair, that when we look at last week and we look at Friday afternoon, the question that we had around what are the costs to the nation? What is the cost to every Gogot Lamini when we keep a process for longer than the stipulated time? What is the cost when the cost keeps on rising? Legal cost. What does it mean for our country, Chair? And it is within that context, Chair, that I am speaking about constitutional duty. There is a constitutional duty to every single public representative that we do right and we do fair by the people of this country. And so everything that we're doing in this committee should be within that context, Chair. And that's why I keep on emphasizing the issue around constitutional duty. And I support what you have decided as the Chair. And I support it for those reasons. Because mindful in the back of our heads are the very things that has been put upon us as people that are representing the people of this nation. So whatever Advocate Bauer is doing it's assisting me as a lay person serving the public. It must assist me to come to a fair conclusion that affects the head of a Chapter 9 institution. Thank you, Chair.
Thank you, Honorable Sukas. This is how we're going to proceed now, having listened to all of you who had raised their hands. Because at some point I was asked to allow members to speak and then take consensus out of those contributions. I think we are at that point now, with three members who contributed in this with a view not to proceed, and 4 members contributing here with a view that we proceed and that we need to attend to the legal permissibility clarity of this issue. We'll attend to that. What we're going to do, we are going to allow Advocate Bauer to continue now until lunch. Though as part of the legal team, they're busy with exactly some of the issues that must be unlocked. We can allow them after lunch to give us a briefing on the clarity that is sought, even though many of us are very clear that there's nothing illegal about empowering members of the committee about the work that they are doing, which is this Section 194 inquiry. Advocate Bauer.
Chair, on your instructions, I was endeavoring to put the context to what precisely we were doing. And maybe if I did that for the next few minutes, there'd be a better understanding of precisely what we're doing. I started off by pointing out to the terms of reference, and the one line I probably didn't emphasize was the nature of these proceedings are inquisitorial, but you said it, Chair, and we are not prosecutorial, which means that we do work with the committee in an endeavor to assist the committee in its task of assessing the motion. Now, the purpose of what we sought to do is to say to the committee, there are extensive court records before this committee in relation to essentially all the reports which form the subject matter of the motion. Those court records have not formed part of the oral evidence to date. We have not extensively, we may have in isolated cases dealt with parts of it, but in respect of CR 17, we have not taken you through any aspect of that. Now, as we go along, I would highlight that which would require a public protector input, and where you would when as members you ask questions, you may want to engage with the public protector on aspects of these court papers relating to CR 17. And we would take the committee through the salient parts of the affidavits, indicating what in respect on the main subjects relating to what the public protector has
On
to
a point
say.
of order. Chair.
Pause, Advocate Bauer. What's the point of order?
So seeing that, Chair, you're proceeding with the inquiry in the absence of the PP legal representation, what happens in the case that Advocate Bauer presents matters that are questionable by the legal team and they are not in this meeting? So what I'm saying is, whatever process you're engaging on now, since this meeting, you said it yourself, it's a public meeting. So let's say the matter of PP legal representation gets resolved in a day or two, and then they go back to this recording. Because remember, you're talking about the inquiry here. So what then happens when there's things that are factually wrong or misinterpretation that is made by Advocate Bauer? Are we going to start this process again from scratch? Just clarity on that one, Chair.
No, thank you, Honorable Maute, for that point of order. The clarity is first, because you've spoken as having made a ruling to proceed on this matter. There would not be a repetition of that. Secondly, this is a feedback and a submission to members, not to the inquiry. This is a committee meeting. And I've said much earlier that what she's dealing with is evidence that has been placed over 6 days. in this committee. And she just started. And over that 6 days, we covered 2 charges, CR 17 and the unit issues, the Godan, and so on. So we've extensively discussed this about what's the purpose of this. So I don't want us to go back now having made that ruling. Thank you, Advocate Bauer.
Chair, maybe if I could add to what you're saying, the public protector has, and maybe Chair, in the days where she did deal with the CR 17 matters and the Godan matters, extensively explained her interpretation of the report and has informed members of various explanations in relation to what she had done in respect of both reports. I don't intend repeating that, and I don't intend putting up argument essentially against that, because that will happen at an appropriate time if we get there. What I'm traversing, Chair, can I finish the sentence, please?
Yes, continue.
Right.
Continue, Advocate Bauer.
In effect,
please recognize me
what,
on point of order.
what I am going to be doing is
Your hand is recognized. Your hand is recognized. Your hand is recognized. Continue, Advocate Bauer. There are other hands that I've seen.
so what I am seeking to do is to show the committee what is contained in the affidavits that have appeared before the courts. And remember, the issue before this committee is that there are review applications before courts. There are then appeals to the higher courts, and then a judgment is written. The judgment is informed by the evidence that is put before the committee. What will then happen when we get to examine the public protector, or alternatively when the committee produces its first draft, is that the public protector will have an opportunity to answer anything that we may have put before the committee that she doesn't agree with, which appears from effectively her affidavits that's before the high courts and those of the other litigants who've responded to it. And if anything is not correctly represented in the draft report which the committee presents, the draft report is provided to the public protector and a legal team, at which point the public protector and the legal team will be allowed to make input on it. So there is a double bite of an Audi to what we are presenting today. We are not going to endeavor to recreate or argue a contrary view to what was presented by the public protector in her evidence. We simply want to show you what is contained in the records that is before court, that is relevant to the evidence that has passed in respect of the CR 17 matter today. So that's the context in which we are doing that in respect of the major aspects of it. We are not, for example, the court record in CR 17, apart from the rescission application, is something like 1,662 pages. The Cordan record is over 4,000 pages. We are certainly not going to be presenting you every page, but we are certainly going to show you the highlights of what is contained in those documentation which had informed the court judgments which form the subject matter of this motion. And that's the relevance of what we're putting before you. You have heard the public protector's evidence in respect of precisely that.
Thank you, Advocate Bauer, for that addition. I hope it clarifies. Honorable members, I see the 3 hands. I just want to say this before I entertain you. We can't continue raising hands and dealing with the same matter that we've extensively discussed, whether a ruling has been made. I want to urge you not to continue in that way, because it's not helping the discussion and the meeting progressing forward. I'm going to give these 3 last hands the last time, and then from there we'll proceed. And I'm asking members to refrain from doing that. Honorable Mautwe, you had your hand up.
Yes, Chair, I think you're confusing us and perhaps the committee members as well, because Advocate Bauer is the evidence leader, and we've got advocate who's the legal representation from Parliament, which is Advocate Fatima Ibrahim, who would you would normally call her if there's any guidance that you need or you want members to be aware of anything, if there's any information sharing you want, but not the evidence leader. The evidence leader leads evidence. And that's where the confusion comes in and the discomfort comes in, Chair, to say, we are actually continuing with the inquiry despite the fact that you said you are stepping out of it. And I'm sticking to that because of what is currently happening. And we put it to you, Chair, that the PP does not have a legal representation. We cannot continue with this sitting without the PP's legal representation. And I asked you earlier, what happens when the things that Advocate Bawa is saying are being challenged by the legal team of the PP when they come back? Say 2 days after today's sitting that you are forcing us to be in. Then the issue of PP legal representation is sorted. They come back. And then there's a lot of things that were misinterpreted by Advocate Bawa, or she misled this committee. They want to challenge that. What then happens? So I don't play us, Chair. I think you're playing all of us. But please, let's allow PP to go get the representation, and then we can continue with this committee sitting fairly. At this point, you are actually making a good case for an unfair process, which will be challenged in the court of law, and you will not win. This parliament will not win. So as members of parliament, we've got a constitutional duty, we agree, but it's also the duty, our duty, to protect this constitution by not allowing you to come and flout the process of this committee. Our names are going to be written in this, and we warn you all the time. Our names are going to be written in this thing, and we'll be labeled as if we agreed with this, and we don't agree. And it doesn't matter whether it's one person or 2 or 3 people. The fact remains, the Constitutional Court said you cannot continue with the inquiry in the absence of the PP. Doesn't matter whether there's 50 committee members and only 1 is citing that, and 49 agrees. Like, you know that the ANC and the DA will always agree, and they form the majority in this committee. So we are appealing to your conscience to say, let's be fair to the process. Let's not waste each other's time. We would have wasted a lot of time and money of taxpayers of this country. This process is very costly, Chair, as it is, and it's very lengthy. So let's not come with things that will make it easy and possible for it to be overturned by the court of law. So we still appeal to your conscience to say, let's postpone this meeting. It will not hurt anyone to postpone until the issue of the legal team is resolved. But continue like this, Chair. You know yourself in your conscience that it is wrong, it is unlawful, it is unfair, it is illegal, but you still continue with it. That's why we are shocked. Where do you get this advice from? We said to you earlier on, okay, if you don't agree with us, call the legal team of parliament to come and tell us that it is their duty, actually, when matters are like this, that they should come and guide this committee. You are refusing also to do that. You bring the evidence to that. She's leading evidence of what? You can't answer that question yourself. Herself, she can't answer that question. You can't lead an evidence in the absence of the inquiry. And you said, it's recorded, you said, we're stepping out of the inquiry. And I made a point earlier on to show you that you are playing us, Chair. We are not discussing the 10th anniversary.
Thank you, Honorable Maute. I think you've covered.
The inquiry. So we can't be convened in this manner. It's wrong, Chair. Please just accept and let's postpone this meeting. I thank you.
Thank you, Honorable Maute. Those points have been made repeatedly many a times. We've discussed that extensively. We've made the ruling in that regard. We're not going back to that. I want members not to repeat the points they've made even before the ruling was made. We're beyond that now. Honorable Zungula and then Dlagood.
Thank you, Chair. I've just listened. In fact, before I speak, based on what I've heard from Advocate Bawa, we've got a constitutional obligation, Chair. Now, this constitutional obligation must be in line with the law. It must be fair. It must follow procedure, and we must avoid any risk of this entire process after spending so much money, time, and resources that a court of law will somewhat overturn the report because we did not follow what the Constitution says. Now, I've listened to Advocate Bawa, what she's saying she's going to do. The first thing, Chair, is that she cannot begin to touch evidence, even if she's summarizing, even if she's summarizing what is presented or what was presented without the legal representative of the PP. Based on her own words, she's going to be presenting evidence or presenting what is before the courts, and she's going to be doing that in the absence of the legal representation of the PP. Now, I would also ask, Chair, in terms of the directives of procedure, where exactly in the directives of procedure allows evidence leaders to summarize evidence in a committee meeting, particularly in the absence of the PP's legal team and the PP herself? The reason why, Chair, I believe that here we're dealing with an evidence leader because, like Honorable Mauto is saying, they are dealing with evidence. Now, you can't deal with evidence in the absence of the legal representation of the PP. If in her own words, she's going to be, presenting information here, presenting what was before the courts on those matters. Like we stated earlier, Chair, what happens if, and she's not just going to be reading line by line, what the evidence before the court was. She's going to be interpreting what she thinks, it was presented or was before the court. Now, what happens if there are cases or issues in which the PP's legal team would want to object? How are they going to object in their absence? And lastly, Chairperson, I'm getting very concerned that it appears that there are some meetings that are outside of this forum, because when did the evidence leaders prepare for this presentation? Because they seem to be very, very ready to present, because the agenda of today was the PP, hearing oral evidence from the PP, in which it was clarified that she can't because of the issue of the funding. Now, when did the evidence leaders firstly get to prepare whatever they're going to present, and how did they know, Ukuba, you are going to give them that particular task and they decided to prepare? So I would say, Chairperson, that the conduct of you insisting that we proceed in this manner, it smells that it appears as if ikona into engapha kokuqonda, because there's no way in which the evidence leaders would be so ready, so prepared, whereas the agenda did not even think or include them actually presenting whatever that they are going to be presenting now. So, Chairperson, please, as the majority of the speakers said, let's get the parliamentary legal services to advise first. I would propose that you don't allow them to speak up until the parliamentary legal services speaks, and we engage that parliamentary legal services, Kukala. And then once we are sorted, we are comfortable, and we are knowing for a fact, in terms of the legal services of parliament, everything is above board, then we can proceed. Otherwise, as she's going to take the platform now, if you are going to give her the platform, we'll raise objections, because in her own words, she's going to be dealing with this window that may be objected by the legal team of the PP. Now, the PP is handicapped now because the inquiry is somewhat proceeding without her legal representation representing her. Thank you, Chair.
Thank you, Honorable Zongula. Just to help you, the evidence leaders were as ready even last week. I ruled them out when they wanted to come in, even before Friday, once the CR17 matters were concluded. So they've been ready, but it's a pity. If you were attending every day last week, you would know that there was that readiness from their side, which I ruled out. So, but I'm not going to be assisting you on that. You represent your own party.
They were ready to protect, not ready to present what you are saying.
I have not even noted you. Please don't do that. Honorable Lagude.
Thank you very much, Honorable Chairperson. Honorable Chairperson, you said the Parliamentary Legal Services will address the committee after lunch. So what we are dealing with right now is the evidence leaders empowering us with evidence that was led last week by the PP's legal team. The material facts that they are dealing with is what the PP dealt with herself. So there is nothing new that is being dealt with here, and the evidence leaders are not leading evidence. They are just empowering the committee within what was led by the PP's legal team. We agree, Honorable Chairperson, that this is a committee meeting and empowering the committee for it to proceed with it to continue and finalize its work, I think is very much important. So, Honorable Chair, I want to plead with my colleagues that we proceed in this manner that we are proceeding with. Then after lunch, as you have said, Honorable Chairperson, the Parliamentary Legal Services will then brief the committee or address the committee. So we are not moving forward as of dealing with a new information that was not touched by the PP's legal team. We are dealing with what was presented, what was addressed to the committee and the public at large. So the evidence leaders are empowering us as members of this committee so that we can move forward and come to a better understanding and better conclusion. So I want to plead with us, let's not keep on coming and disrupting the proceedings which we are proceeding with. The evidence leaders are empowering us as the committee. Can we allow that? We have a responsibility and duty to finish our work. We have a responsibility and duty to produce credible report and findings as this committee. We must be ready. We must understand the issues. So I urge my colleagues that we allow the evidence leaders to brief us. Thank you very much, Honorable Chair.
Thank you, Honorable Tlabude. Just before I go to Advocate Bauer, to repeat the points that were made as we made that ruling. And members would have also even echoed that this is not an accusatorial process. This is not an adversarial process. This is an inquisitorial process. And therefore, the fears about what this, once this is placed, it will prejudice somebody else, are really not existent in terms of the process that we're following. I have made a ruling having listened to members extensively, not once. And I think from this point, if there's an intention to just object willy-nilly, we'll have to apply our rules as Parliament, because there's got to be a decorum of the process and a meeting of the committee. Advocate Bauer.
Chair, in doing this presentation, we still anticipate that we would, when the time is there and the PP's difficulties with legal representation is sorted out, that we would ask questions from any issues that get raised. We would also anticipate in the course of this presentation to alert members to what questions we would need to ask, arising from any differences that we may have found emerging from the affidavits before court and what had been put before the committee. We don't certainly intend providing an opinion because of what's there. We have been at pains to say to the committee on several occasions that we don't have a burden of proof. We don't have a case to make out. It's our job to present the evidence. We certainly, in taking up the time of the committee, they would know what evidence had been presented in respect of the CR matter already. We do not intend wasting your time by repeating that, but we do need to alert you to evidence which are on the court records, which say, which deal with the subject matters that was dealt with before the committee in doing that. And so you will know, and I'll ask Shepherd to put it up on the screen. The first full court record is at bundle H31.7.5. It was actually put up by the full court record appears from the public protector's papers. And for the committee's benefit and for those who are not legally trained, if I take it down to the basics, if you, this is by the time you reach the Constitutional Court, what is encapsulated in the court records are the affidavits of the applicants, which you will see in this matter was the public protector and the economic freedom fighters. And then you find that it's the respondents that file affidavits that answer the averments of the public protector when you're in the Constitutional Court. But when the case started off in the High Court, what you had was that the president brought an application reviewing the CR17 report and the decision of the public protector to write a report of which the subject matter included the CR17 campaign. That was the subject matter of the review application. The public protector then went on affidavit and responded to the president's allegations. The president then filed a replying affidavit, and the matter was then argued before a full bench in the North Gauteng High Court. The judgment came out in short, finding in favor of the president. The public protector then took the matter on appeal directly to the Constitutional Court. I'm not going to deal with all the subsidiary applications that happened, safe to mention it, because there's also an application from the EFF to intervene, and there's all kinds of other intervening parties. As I take you through the records, I'll highlight that as it comes along. What then happens is in the Constitutional Court, the matter is then an application for leave to appeal. The matter is then argued. You have been taken extensively through the minority judgment that had been handed down by Chief Justice Mkhwebane, as that is already before the committee, having been put before the committee by Advocate Mpofu. I will correlate that to the passages of the affidavit of the judgment handed down by the majority of the Constitutional Court after the order was handed down by the Constitutional Court, effectively dismissing the appeal by the public protector. An application for a rescission was brought by the public protector to have the judgment of the Constitutional Court rescinded. In that rescission application, the public protector filed an affidavit, and the president answered that affidavit. So it is in that broad context, that being the papers that served before the courts, which informed the judgments to which you'd been directed. And as legal practitioners, and some would know, the judgments are informed by those affidavits that are put before it. And it is to those affidavits that we are turning in doing that.
Please mute that member. Thank you. Proceed.
Right. So what we do now is that the PP's affidavit, so in the context of what we have with the PP, we know that she has put an affidavit before this committee, which for purposes of making it easier, you will see at bundle H, item 37.1 at 497. is where that appears. Again, with reference to the PP, we have a court record in which she filed an answering affidavit dated 7th August 2009, which you will see in the court record at page 427. You have a second answering affidavit which she files dated 14th November 2019. And you see that it's 756 of the papers. And then we have a founding affidavit in an application for leave to appeal directly to the Constitutional Court in terms of Rule 19.2, which you'll see dated 14th April 2020, and you find that at page 1443. The president's affidavits, he did a founding affidavit, a supplementary founding affidavit, and a replying affidavit. And the page references for his founding affidavit first starts at page 8. The supplementary founding affidavit starts at page 450. And the replying affidavit starts at page 1226. The application for the rescission is to be found in the context of bundle E. And one sees that in bundle E of the documentation at number 10, and the notice of motion is number 3 of bundle 10. The public protector's founding affidavit is number 4, and the president's answer is at number 5. And so the evidence encapsulated before this committee contains all those affidavits which I've now highlighted and brought to your attention, because they are all properly before the committee and should be considered for purposes of the motion. Right. As I've indicated, there are applications in the same proceedings brought by the Economic Freedom Front, the Financial Intelligence Center, the Mkhwebane.
Economic Freedom Fighters or Front. Okay.
My apologies.
All right. Thank you.
Shall we call them the EFF, the Financial Intelligence Center, FIC, the Mkhwebane organization. There have also been affidavits filed by the Speaker of the National Assembly and the National Director of Public Prosecutions. So it's quite an extensive set of affidavits, which is before the committee. We had last week, and to put it into context, especially for members who were not here last week, the debate started, or one of the issues that had been dealt with was the Executive Members Ethics Act. This might be a convenient time if you wish to take the lunch adjournment before I start on the substance of where I want to take the committee, unless you want me to just background it in the legal precepts before I go to the evidence.
No, thank you. It was my intention that we'll take lunch at 1. Thanks for bringing that up to me. It's now 1 o'clock, colleagues. We'll take lunch.
Recording stopped.
I can hear you, Chair.
Thank you. You sound better and you seem to have increased the volume now. Thank you. We proceed, colleagues. I indicated before lunch that before we proceed with Advocate Bauer, we'll just get a few minutes update on the specific question that you ask about the legality of the approach and process, and in fact whether the what I've directed Advocate Bauer to do, whether that is outside of what we need to do, whether it prejudices the public protector and so on. But it's not an all over the place kind of explanation. It's kind of very specific to our tools of trade here, our rules, directives. So I've just asked for this part, I've just asked the evidence leaders to wait for us outside M46. And I'm going to invite Ms. Fatima Ibrahim to quickly brief the members as you would have requested. Thank you. Over to you, Ms. Ibrahim.
Thank you, Chairperson, and good afternoon to all the members and colleagues on the platform. Chairperson, I've had a short while to just quickly apply myself to the questions that members have asked. And I just want to, if you'll allow me, to take the committee back to the time before we commenced with the hearings, at the time when we were still debating how this process would look and how it would unfold. And members will recall that when I originally presented the possible formats that the inquiry could take, there were three options at the time. One was to have evidence leaders. The other was that the process would be entirely member-led with internal support from the parliamentary staff. And the third would have been a hybrid approach, where you didn't necessarily have evidence leaders being the face of the committee, but that you would have some expert assistance in the background. And given the complexity of the charges and the volume of evidence before the committee, it was decided that the best approach would be to use evidence leaders, because members will recall, even at that time, the panel report itself and the evidence bundle, they went into thousands of pages, and it was felt that it would be a better approach if we had the support of evidence leaders. We were at pains, Chair, to advise at that time that this isn't a quasi-judicial process, and that the use of evidence leaders should not be seen to be a admission on our part that this is a trial of any kind or a criminal process or anything akin to that. And therefore, in the TOR, we specifically stated that the nature of the process is inquisitorial, and that the evidence leaders will have two roles. One was to put questions to witnesses, if witnesses were going to be called, and secondly, to present evidence. But the rider to that, Chair, to both of those, was that the aim of that would be to empower the committee to assess the merits of the evidence, because I've made it clear from the beginning, it's this committee that must make the decision. It's not evidence leaders or anyone else that usurps the role of the committee, and that members must be engaged in the process. The presentation of evidence, Chair, can take various formats. We tend to think of the presentation of evidence being one where witnesses are being called and that evidence is presented via witnesses or through witnesses. But that is just one way in which evidence can be presented. There are mounds of documentary evidence that doesn't necessarily have to be led through witnesses. It would in fact be impossible to lead those all of that evidence through witnesses, because as I say, they go into thousands of pages. And the directives specifically say that the evidence leaders may present evidence without necessarily leading that evidence through witnesses. The question thus is not whether the evidence leaders can or can't take the committee through evidence. I think that that's established. That is their role, to take us through evidence. The question is whether they can do so now in the absence of the PP and her legal team. And to determine that, Chairperson, I remind the committee of what I've called the golden thread that runs through the proceedings, which is that the process must be fair. That's always the departure point when we have to deal with any question. And to determine fairness, what one has to then determine is whether this presentation of evidence would prejudice the PP, and if so, how it would prejudice the PP. Chairperson, my understanding is that the PP will be afforded an opportunity to deal with whatever evidence is presented here today. And in fact, there are two further opportunities built into the process. The first is the intention that the PP herself must appear before members and answer the questions of members and the evidence leaders if they have any questions to put to her. The process that the evidence leaders now seek to do is to equip members to ask those questions. Thus, anything that may be disputed, any gaps or contradictions that may arise as a result of the evidence that is being presented can be dealt with her, and an opportunity will be given to her to deal with it. The second bite at the cherry, Chair, as it were, would be the opportunity that the PP is going to be given to comment on the draft report. And you will recall again that before we started the process, I said to respond to the charges, which indeed we did at the commencement of the process already. The PP didn't avail that opportunity, but that we would give a second Audi opportunity once there is a draft report. And the purpose of that was in case the committee missed anything or misunderstood anything, there should be another final opportunity for the PP then to place on a record any corrections or anything that she wanted the committee to consider further. So therefore allowing the PP now to engage with this evidence and refute it. In a manner, Chair, therefore, it can be said that the PP would now be at an advantage, possibly, because aware of any of these contradictions or gaps or other difficulties that the evidence leaders will present, and have the opportunity then to prepare for possible questions arising out of that from members or during questions from the evidence leader. If this were to have been an adversarial process, that wouldn't have happened, because a prosecutor would keep their cards close to their chest, rather than saying, this is what we identify as particular problem areas or issues or things that we may need further evidence on to resolve or to close. So the committee can digest the presentation, Chair, but it would be subject in terms of using the information that comes forth in the presentation today to the PP importantly being given that Audi. So in other words, where that Audi is not given, then reliance cannot be placed on evidence presented. Nonetheless, Chair, there are always, has been very litigious to date. It would of course have been ideal if the PP's team and her legal team were here, but unfortunately that is not the case. At the same time, the committee has a duty to ensure that it proceeds in a manner that ensures that its work is done in a reasonable time frame. I'm comfortable, Chair, as long as what I'm saying in terms of the issue of reliance is seriously considered, and that nothing goes in to the report without the PP then being given an opportunity to respond specifically to that. Thank you, Chair.
Thank you, Ms. Fatima. Ibrahim, you have taken exactly 7 minutes to do that, to make those clarities in assisting the members in answering the questions that were raised. Before I call in the evidence leaders for us to proceed, I'm going to check if there are any clarities from what has been presented now by Ms. Ibrahim, which clarifies some of the questions that we ask. Mr. Honorable Zungula.
Thank you, Chair, and thank you to Ms. Fatima Ibrahim as well. 2 issues, Ms. Fatima. The first one is, what then happens if during the process of the equipping done by the evidence leaders, there are issues in which the public protector via their legal representation would want to object. How then would that happen? Or is it going to be a case whereby immediately when they are done, when this thing of the resources or funding is done, then they'll have to come back and start from scratch and object everything that has been done by the evidence leaders? That's the first point. The second point is immediately when the evidence leader is done, what then becomes the next step in the context of the proceedings? And the last issue is that with the court order saying the evidence leader, the PP is entitled to legal representation throughout the entire process, do you view this, what will be done or what is currently being done by the evidence leaders as part of the process? Because I get this argument that they're an extension of the committee, of which in my view that is false, because a committee is members of parliament. Like yourself, we are providing assistance. You are not a member of parliament, not a member of the committee. You are requested time in time and whenever necessary to provide assistance, and you are providing that assistance objectively so, because you are not going to need to make a determination after the entire process. But with the evidence leaders, they are leading evidence, they've been leading evidence from the start up until this process. So how then do you reconcile the need for legal representation throughout the entire process? And you are going to have this particular process or part of the process which excludes the public protector, because the public protector is effectively not part of the meeting now. It's a committee meeting. So that is the 3 points, particularly the last one is true. On one side, an extension of the committee. On the other side, the evidence leaders. On the other side, the committee comprises of members. And as the chairperson stated earlier on, this session now is open for the members to assess. And perhaps the last point, would you not, as someone who's been providing legal and technical advice in the past, would you not be the most relevant person, as you are not intricately involved in leading evidence? Would you not be the perfect person to provide whatever legal assistance members need when it comes to equipping them or assisting the members in this particular stage? Thank you.
Thank you. Do you want to take, or should I put them together, or want to take them one by one? Is it easier that way? Over to you. I've noted Honorable Maute, Honorable Gondwe.
Thank you, Chair. That was quite a bit, some of which were remarks, but I'll Chairperson, I think what is key in terms of the question around objections. Objections can be raised at any point. It doesn't need to be done immediately when something arises. But the key is that we have to deal with what possible prejudice there would be to the PP. And I've made it clear that the information that is provided here today cannot be used against the PP without affording the PP an Audi to respond to that. So whether that's going to be in the form of members putting questions to her saying, this is what the evidence leaders presented in terms of X, Y, and Z. What is your response there to providing an opportunity that way? And then secondly, if it's included in the reports, in other words, the committee then plays on evidence presented in the report in order to reach a finding, she must be given an opportunity then again to respond to that. Chair, the nature of the proceedings is such that the role of legal services here would be to give technical legal advice and not to take the committee through the evidence. Certainly the legal team is not steeped in the evidence in the same manner in which the evidence leaders would be. In a normal committee process, had the decision here been not to have evidence leaders, this would have been a role played by content advisors, typically, who would have studied documents and legal might have assisted on particular legal questions. But it was the it was a decision of the committee to follow this particular route. As I've said, Chair, it would have been ideal if the PP, but unfortunately that is not the case, and the committee then sits with this issue of still having to conduct its work within a reasonable time frame and completing its work, because there is a lot of evidence before the committee that the committee is going to have to engage with. And the question is how best the committee can do that. Chair, we had envisaged that even when we get to the point of deliberations, where the role of the PP's legal team would have come to an end during deliberations, that reliance may then even be placed on evidence leaders to assist the committee where there are these technical questions where members perhaps are not understanding or following the evidence, because they would understand the evidence in context, and that they could have assisted the committee in that regard. And any attempt by the evidence leaders to persuade the committee in a manner in which they shouldn't have, because they're not meant to be biased. They sit here as neutral, and I've made it clear from the beginning. They put evidence before the committee, whether that evidence refutes or supports. The point being that the public protector would have still had the opportunity in that final draft report to have a look and then make her comments. Thank you, Chair.
Thank you, Honorable Mauta.
Chair, my apologies, Chair. Can I come in quickly?
No, I'm going to take other members. If there's a quick follow-up, I'll check you at the end.
It's not a follow-up, Chair. It's just to highlight what was not answered.
Okay, go ahead.
Yeah, it's the question, Chair, regarding the court order that stipulates that the PP must be afforded with legal representation throughout the entire process. I think she forgot to answer that one, because the legal evidence leaders have stated that they are dealing with evidence. How do you reconcile this is what this is happening now versus that particular court order in relation to the presence of the legal representation of the PP? Thank you.
Thank you, Honorable Zungula. A quick one, Ms. Ibrahim.
Chair, there's been no denial of the right to full legal representation, but there is another part of the process, which is the committee getting to grips with all of the evidence before it. And certainly when the PP returns with her legal team, the legal team, should they wish to engage on any of these issues, then of course they must be given the opportunity to do so.
Thank you. Honorable Mauta.
Yeah, thank you, Chair. Chair, Ms. Ibrahim just confirmed that we are going to be dealing with evidence. She said it herself. She even says if any evidence that is going to be presented now might be questioned by the PP, they can do that later. So it means it's very clear that we're continuing with the inquiry in the absence of the legal representation. And that alone, you don't need any other explanation. That alone tells you that we should not proceed. That's one. So, number two, the program for today, Chair, and I'm going to repeat this because it's what you circulated. The program says we are hearing the evidence by the PP. The PP is not here. So what are we doing? She's not here. It's unless if you've got a new agenda, which you have not shared with us. But what you want Advocate Power to do is not in today's agenda. So why are we deviating from our agenda? That's number two. Number three, it's an observation, Chair. I've been observing that ever since the PP took the stand to give a testimony or evidence in this committee, Parliamentary Channel 408 has never, not once, televised that. But today, because now the tables have turned, it's no longer now the PP leading evidence. It's now the evidence leader Advocate Bawa gonna be taking on the PP. Suddenly the Parliament's channel is back on. That's bias. That like it's very wrong. So the public don't know the evidence that was presented by the PP throughout from day one. Are we saying that the public is not supposed to hear the side of the PP? It must only hear the side of the evidence leaders? That's wrong, Chair. Why are we doing this? Really? Now, finally, let's postpone this sitting. It will not hurt anyone. Let's have this sitting properly constituted with the legal representation of the PP, as it is an instruction by the Constitutional Court. All of you will be breaching that instruction by the court. And we don't want to be part of that. We don't want to be someone, we don't want to go to jail for nothing. We're not scared of jail, but we must go there for real reasons, not this thing of not following court orders. So let's not do the wrong things, Chair, please. Thank you. And please advise the parliamentary channel that we are watching what they're doing. They're playing politics and it's very wrong. And we're going to say it publicly. We're not scared to say it. It's very wrong. They can't give the side of the other people and not give the side of the PP. The whole world wanted to hear the side of the PP. It was not anywhere. Even when there was nothing happening in parliament, they will repeat things of the past, of parliament of the past. Today, because now it's Advocate Bauer. Since the morning, you can go and check it yourself. She's been there. It's very wrong. And we're cautioning parliament to say, stop what you're doing. It's wrong. Thank you, Chair.
Thank you, Honorable Maute. Before I go to Ms. Ibrahim, there are issues here that I might have to respond to as a chair. So if there's any issue you want to respond, you can. If none, I will respond later because there are two critical issues she would have raised. Let me proceed to Honorable Ngosi. Honorable Gondwe, and then Ngosi.
Good afternoon, Chair. Thank you very much for giving me the opportunity to
maybe just before I allow you to speak, I'm just going to make a request to those that are following. I'm giving you this opportunity to seek clarities on what you're taking the platform is specific to that. Thank you.
Chair, I don't have a clarity seeking question. I just want to agree with the insights that Ms. Ibrahim has given us. I do agree that by us allowing Advocate Bauer to take us through the court records that are relevant to the CR17 matter, that will in no way prejudice the public protector. And as Ms. Ibrahim has indicated, she will have an opportunity, to be heard. And should she want to set anything, straight in terms of what has been presented by Advocate Bauer. Chair, I also want to just correct a misconception around her right to legal representation. The Constitutional Court didn't say that this inquiry cannot proceed without her having, legal representation. It said that she must be afforded an opportunity to have a legal rep assisting her. And we've not denied her of that right, Chair. And I just want to put that on record because there seems to be a misconception being peddled around us denying her the right to legal representation. We've never done that and we're not going to start doing that. Thank you very much, Chair.
Thank you, Honorable Maute Gondwe. I don't think there's anything Ms. Ibrahim needs to. You were making a contribution. Honorable Ngosi.
Thank you, Chairperson. I'm also not going to ask for clarities. Just to say I'm better positioned now to agree with you. Firstly, that in the morning we took a decision. We are adjourning or postponing the inquiry. So there's no inquiry here. We took a decision in line with that we are proceeding as a committee. Right. As a committee, we do have a right to utilize whatever resource that is availed to us to enlighten us. One of that resource is the evidence presenters, sorry. And it's true, we made an election that we are going to have evidence presenters guide us through the process.
We call them evidence leaders.
Evidence leaders, yeah, guide us through the process. And I think there is nothing wrong. We've done that. Otherwise, what they're doing now, or what they were doing, can be done at any time. We can adjourn the meeting after presentation of part 1 and part A and part B, and request that they take us through all what has been presented by the public protector's legal representative. The alternative, Chair, is that we approach them individually for advice, but that's not how we are structured. We are structured as a committee, and we can receive, and we can and should receive advice from them through as a collective. And I think that I think we must bury that. In any way, Chair, the records of this committee meeting are public records, accessible by any other person interested in this process, and in particular, the public protector. So they can avail, if there's anything that they want to object to, they've done that before. They can object to things that are said in committee, in the inquiry itself. The last point, I think, it's just as a matter of emphasis again, that there's no one who's denying legal representation to the public protector. In fact, we are on record on several occasions, even when they staged a walkout here, his legal representatives, as having emphasized the fact that we will not proceed without these legal representatives, without the legal representatives being there. So we cannot suddenly be this committee that denies that representation, Chair. Other things, Chair, I think, yeah, maybe we can discuss it. I just wanted to discuss the issue of the budget and how the budget works in Parliament, because I've heard several times, on several occasions, the PP directing us to go to the fiscus, to go and get money from the fiscus. Just to make the point, Chair, that a budget is a law of the country. It is the Division of Revenue Act, and it is spent according to the law, according to that act passed by Parliament. And you cannot, once you pass the law on finances, just go anywhere and get this money as if it's available. I'll make the point when she's here. So thanks, Chair.
Thank you, Honorable Ngosi. The last hand I have is Honorable Siwela. Honorable Siwela.
Thank you, Chairperson. Thanks, Chair. I was being participate even earlier than this, but because of network, I could not. So, Chair, I don't have much to say.
It will help your network if you just switch off the camera. Just switch off the camera, then we'll just switch off the camera, then we'll hear you. Yes, thank you.
I have done so, Chair. I wanted you to see my face, that this is well indeed. Chair,
Thank you.
I'm saying,
Thank you.
I don't have questions, but to support that we proceed, because, Chair, this is not, and the presence of evidence clarifies certain things. And as clarified by Ms. Abraham, I am comfortable that we are not violating any law. And I'm happy that the PP will get an opportunity during the right time to respond to us, as long as what we are doing is legal and we are not violating any laws. I'm proposing that we proceed, because our evidence leaders, they are the extension of the committee to
maybe advise us and clarify certain things legally, which on our own we cannot. So that was my view, Chair. Thank you.
Okay, thank you, Honorable Suela. Thank you. To conclude and address some of the concerns raised by Honorable Mautwe, just two of them. Though I'm not aware, because I'm always on this seat, wouldn't know when we're on 408 or not. That's probably something that can be taken up to clarify, but what we all do know is that that platform gets to be shared amongst a number of committees at any given day. So there would be NCOP running, there will be NA committees, there will be sittings running in that, but would not follow it. So there's, in other words, I'm saying it's a contested space for parliamentary committees. I've been told that it's Wednesday and Thursday where it would not have been running, and that in the absence of that, there would have been YouTube and so on. But thanks for bringing that. But I hope it clarifies, because it's not our space as this committee. But the point you're raising is that it's important that the public connects with everything that we do. And in that regard, that in the absence of 408, the public, which I acknowledge every day, and I mentioned 408 and YouTube. So when they are not on 408, they are on YouTube. And they always tell us when our sound is not audible, when they're frozen, we always are alerted on that issue. But it's good that Honorable Mautwe has been alert to that issue, that when you inquire, you could easily be told that Section 194, you are not the only committee that we have in Parliament. We cover this and this and so on. I think we have addressed the other issue raised much earlier on, as we made the ruling about your question about what we're doing here now, and that the agenda would have been about the inquiry. We've traveled that road. We've explained when we switched off from this and get into a committee session. And I hope that does help. So that being said, colleagues, Ms. Ibrahim, any last word you want to say before we conclude and ask the evidence leaders to come in?
Yeah, Chair, just for the record, the evidence leaders on, as I said in my response to Honorable Zungula, they are resources to the committee. They cannot usurp the functions of members. They're here to capacitate members to do their job. Thank you.
Okay, thank you. That in that way, because you would have followed that, because the chair would have used that language. So the chair stands corrected on the extension, but it doesn't take away the fact that evidence leaders are part of our design in a way we've designed this inquiry. Thank you for that, Ms. Ibrahim. Can we call in the evidence leaders to come and continue? Thank you.
Recording stopped.
as I indicated, that today's presentation relates exclusively to the CR17 matter, but there is an overlap in respect of one aspect where it goes to something that was raised in the Kurdan matter that has overlapped. You will specifically recall that we had not led any other evidence on the CR17 matter specifically, save for the questions that we posed to Mr. Rodney Matabor, who testified that he was the chief investigator and that the only investigator in respect of the CR17 matter, and he reported to the public protector. So I had taken you through the number of affidavits that the committee has before it, emanating, and I've highlighted the ones that emanate from the public protector and the president specifically. Now, to put this into context and for the benefit of the members who were not here last week and who hadn't yet had an opportunity to comprehensively look at the evidence that was led, I just want to briefly touch on, I'm going to the executive members, the ethics code first, but so let me just locate it for you as to where located. And if I ask Shepherd to just put up section 96 of the Constitution. Right. So if you see subsection 1, members of the cabinet and deputy ministers must act in accordance with code of ethics prescribed by national legislation. If you then go to page 454, that is the national legislation, which says to you in its intro to provide for a code of ethics. Section 6, section 2(1) first. Right? It's headed Code of Ethics, and I'm taking you only to subsection 1. Sorry, before you go to 3, let's just go to 1. The president must, so the obligation is on the president, after consultation with proclamation in the Gazette, publish a Code of Ethics, prescribing standards and rules aimed at promoting open, democratic, and accountable government, and with which cabinet members, deputy ministers, and MECs must comply in performing their official responsibilities. So we know that there is this code and how that code must come into effect. The following subsections tell you what the codes of ethics must contain. We'll skip over that. We'll go to, we know that the code that emanates from this process is the Executive Ethics Code, right? Now we go to paragraph section 3, right? That's the power that's given to the public protector. You will know from, and I think it was done by Mr. Ibrahim a long time ago, that said the public protector's powers must be sourced in the Constitution or in legislation. Under EMEA, which is the Executive Management Ethics Act, her power comes from paragraph section 3(1). The public protector must investigate any alleged breach of the Code of Ethics on the receipt of a complaint contemplated in section 4, right? So let's go and see what does section 4 tell us. Go down. Section 4 tells us the public protector must investigate in accordance with section 3 an alleged breach of the Code of Ethics on receipt of a complaint by 1, the president, a member of the National Assembly, member of the National Council of Province. The complaint is against a cabinet member or member of the provincial legislature of the province if the complaint is against an MEC. Subsection 2 tells you that this complaint must be in writing and it must contain the name and address of the complainant, full particulars of the alleged conduct of the cabinet minister, deputy minister, or MEC, and C, any other information that may be required by the public protector or prescribed in the Code of Ethics. Right? Subsection 3 says nothing in this section prevents the public protector from investigating any complaints by a member of the public in accordance with the Public Protector Act. So So boundaries of the legislative powers are prescribed. And if you go to the affidavit, and I'm going to start by the last proceedings in court first. We're going to go to the Public Protector's founding affidavit in the Constitutional Court in the rescission application. That's in bundle E, number 10, and you look at so go to page 7, paragraph 19. Right. The Public Protector correctly points out that Section 3 empowers the Public Protector to investigate any alleged breach of the code. The Public Protector's powers to investigate is triggered by the lodgement of a complaint. This suggests that the scope of an investigation is determined by the alleged breach in the complaint. It is important to note that Section 3 does not authorize the Public Protector to investigate a violation of the Act itself, but limits her authority to investigate a breach of the code. The Protector herself tells us that her powers and her authority is limited under this Act to investigate a breach of the code. The Constitutional Court, in paragraph 16 of its judgment, have you got it there? It's the one of the judgments you've opened. Yes. If you go to paragraph 16. Right? Then looks at what is said in form 4. It says the form prescribed for the complaint and must contain the name and address of the complainant, must also set out full particulars of the breach of the code and identity of the person against whom the complaint is lodged. Paragraph 17 says, a member of the public cannot be a complainant in relation to a complaint submitted in terms of Section 4 of the Members Act. Now, you will see when you look at the Public Protector's report, she handled this properly because she received a complaint from a member of the public and she did not deal with this complaint from the member of the public under EMEA because she is precluded from doing so under that Act. So that's essentially what circumscribes the powers of the Public Protector to investigate the complaint under the Executive Ethics Code. The court, if we just leave this affidavit for a moment, we don't need to go to it. I'm going to read it to you. Right? The President comes to court and he challenges the PP's decision to investigate and report on the CR17 election campaign for the ANC leadership election, which was to occur in December 2017, and to have reports 37 of 2019 reviewed and set aside, in particular certain remedial actions. So he comes to court and he sets out a number of grounds, which I'm going to come to in due course, on which he challenges this report, right? But what the Public Protector does, if we go and we have to start at the start of it, what is it that came to her in the form of a written complaint that got her started off to investigate? If we go to her report, right, if you go to page 9 of the report, you will know that there were 2 complaints and one from Mr. Shivambu. And what the Public Protector then does to the 2 complaints is she decides to consolidate the 2 complaints into one investigation for administrative purposes. Go back up. I just want to show the members What else she did that was in respect of the anonymous complaints. Go to page 8. The bottom of page 8. There we go. She says, not long after the receipt of Mr. Maimani's letter, my office received another similar complaint lodged by Mr. Shabambo and the details of that. And then she says, as well as an anonymous complaint, go down, 28th January 2019, who is not a member of parliament and therefore precluded from lodging a complaint in terms of EMEA. So we know that the complaint is circumscribed by what has been provided by Mr. Shavambo and Mr. Maimani under the code and under the act. Right? What she does in this report, if you go to page 11, she identifies 3 issues that she says informs the investigation with reference to the 2 EMEA complaints. So she tells you that on top. And she says, taking into account the fact that the president was then the deputy president and thus a member of a National Assembly, the following issues had been identified. So the public protector correctly says, at the time when the events occurred, he was a member of the National Deputy presents and he makes the representations to Parliament. He is the president. There is no error in respect of that, in how that was pointed out. Now, under A, the 3 items, and we're going to have to deal with this in some detail for you to understand as we go along what the public protector had identified as the issues to be investigated. Whether on 6 November 2018, during a question session in Parliament, President Ramaphosa deliberately misled the National Assembly and thereby acted in violation of the provisions of the Executive Ethics Code. Now, if we stop there, we know that he's the president and the Executive Ethics Code would have applied at the time he answered at the question session. What is then added onto that is, and the Code of Ethical Conduct and Disclosure of Members' Interest for the National Assembly and Permanent Council members, that for when he was a deputy president. B, where the President Ramaphosa improperly and in violation of the provisions of the Executive Ethics Code and disclosure of members' interest for the National Assembly and Permanent Council members exposed himself to any situation involving the risk of a conflict between his official duties and his private interest, or use his position to enrich himself and his son through businesses owned by African Global Operations. That's the second item that has been identified. C, whether there is an improper relationship between President Ramaphosa and his family on the one side and the company African Global Operations on the other side, due to the nature of the 500,000 payment passing through several intermediaries instead of a straightforward donation to the CR17 campaign, thus raising the suspicion of money laundering. Right? Now, the public protector then the laws in the report to which she had regard. And if you go to page 12, and the evidence was accepting of this, that if you go down on the laws that applies the Constitution, we come to see that what is quoted in the report is section 12 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, which we commonly know as PRECA. And in the report, it's called PACA. Right? Sets out what the offense is that the person commits under PRECA. Okay? That is not the money laundering offense. And I think during the evidence, it was accepted that the reliance on the Prevention and Combating of Corrupt Activities Act was incorrectly relied upon for purposes of finding the offense of money laundering. But that does beg the question for the committee to have an understanding as to what is the offense of money laundering. And it's set out, and bear in mind that when we go through this, what I'm looking at is what was before the court at the time it handed down its judgment, because it's the judgment that forms part of the motion. So if you go to the founding papers, which would 5, yeah, if you go to page 57, what I'm taking you to now is the president's founding affidavit in the High Court application. Before that, I think to put this into context, let's go up to the top, the start of the subsection dealing with money laundering. I am mindful that I have to give the committee a context of how this coming. Okay, so the president comes to court and he says there's an irrational finding of fact and there's no basis for money laundering finding, right? And he says that the public protector concluded that there was a prima facie case of money laundering against me, and she referred the matter to the National Prosecuting Authority. And he says, in his view, there whatsoever for any suspicion or prima facie case of money laundering, the public protector does not set out why she believes that the suspicion of money laundering is sustainable. And I'll come to what the public protector says in a moment. Money laundering is a statutory offense in terms of the Prevention of Organized Crime Act 121 of 1998. Nowhere does the public protector reference this act in her report. In terms of section 4 of that act, the person is guilty of money laundering if he knows or ought reasonably to have known that the property forms part of the proceeds of unlawful activities. That's the first element. Second, despite that knowledge enters into an agreement or engages in any arrangement or any transaction with anyone in connection with that property or performs any other act with such property. Thirdly, the effect of any agreement or any other act must be to conceal or disguise the nature, source, allocation, disposition, or movement of the said property or its ownership, or must be intended to enable any person to avoid prosecution or to remove or diminish the property in question. Now we know that in this case, the complaint related to the 500,000, that would be the property in question. President then goes on and he says the public protector did not engage with this definition at all. There's no basis on the findings that she had made for a suspicion or prima facie case that there were any unlawful activities. Nor is there any basis for the suspicion of a prima facie case made out that there is any person that knew that any unlawful activity were carried out in connection with any monies. There is no evidence at all that anyone or engaged in a transaction to conceal the nature, source, location, disposition, or movement of any monies or down. Right. And then he says, it seems that the public protector merely concluded on account of the fact that the money was paid initially to Miyota Trading before it came to EFG2, that this was an attempt at disguising the source. As a matter of law, this is wholly incompetent. There's no factual foundation for this view either. The CR17 campaign had no way of knowing why a donation sought from Mr. Watson was paid via an associated company. The public protector had access to both Mr. Venter and Mr. Watson. Neither of them gave the public protector any information to the effect that there was ever any attempt or intention to disguise the source of the funds. So the Precker Act indicating that it doesn't apply, and that Precker deals generally with the offense of corruption. Corruption and money laundering are two legally distinct concepts. By confusing these statutes, the public protector has shown a grave misunderstanding of the law. And then he comments on that in respect of that. Now, if I take you to the public protector's affidavit, which one sees at page 856. noticeably, I was dealing with paragraphs 150 onwards of the president's affidavit, and you would know, maybe go up. Right. So as you would know, one deals in an answering affidavit in two ways. You set out your main submissions and seriatim, or paragraph by paragraph with the allegations that you find in the founding affidavit. And this is what the public protector had to say in respect of the president's submissions relating to inter alia. You used pricker as opposed to poker, and you got the legislation wrong in this regard. The public protector says the allegations contained herein are denied. The evidence contained in the record is clear about the movement of funds. The moving of funds from one account to another raised suspicion of money laundering. Go down. Stop. Having regard to the alleged suspicion, I reviewed the bank records of the EFG2 trust account to establish how the funds which had been collected from the CR17 campaign were disbursed. There were large sums of money entering and exiting this account. This compounded the alleged suspicion of money laundering. I found that because payment of the 500,000 passed through several intermediaries, and the several intermediaries phrase comes from initially Mr. Mkhwebane's complaint, instead of a straightforward donation towards the CR17 campaign. So it went from Mr. Watson's personal bank account to the Myoto trading account to the EFG CR17 campaign account. The suspicion of money laundering had merit. I therefore referred the matter to the relevant institution for probing as provided for in section 64CI of the Public Protector Act. Legal argument will be advanced at the appropriate stage as regards the scheme. It will be invidious for a court to mark the work of the Public Protector academic essay, or for it to expect the report to read as a court judgment. Save as aforesaid, the allegations contained herein are denied. So at that stage in the High Court proceedings, based on the affidavits, the Public Protector did not admit that she used the wrong legislation. And when the Public Protector comes and testifies, we will ask her where in the main body of the affidavit she dealt with the allegations that it was the prevention of crime, pricker as opposed to poker. Chair, may I at this point say, because we're an inquisitorial process and not an accusatorial process or adversarially nature, what this also does is it gives the Public Protector a heads up on the question they had the matter run up the course. But I'm not asking her those questions now, nor am I drawing any conclusions from the answers to be drawn. But as you would be aware, this note had initially been prepared last week with the purpose of doing this and then asking the Public Protector questions. Right. So from there, one then goes to the High Court judgment, which is 30 of bundle C. Got it? All right. If you go to paragraphs 140, sorry, I don't have the page number. 140. Paragraph. Yeah, 140. There we go. Maybe go back up. So if we start, just stop there. So 139 is probably, it doesn't start midway through 139, but before I'm accused of misrepresenting it, let's just start at the top of 139. All right. I haven't yet dealt with the facts, and so we will come back to 139 when we deal with the facts, but maybe we'll just put it into context, because here the court in its judgment, which is already 59 pages in, says, we know that the public protector did not have facts or evidence that the donors were either public officials or that public funds were used to donate to the CR17 campaign. In fact, the evidence identified the donors as private donors. It is inexplicable how then the public protector made the state capture statement. To buttress her view, the public protector then referred to Pricker to found a conclusion that money laundering was involved. She made the firm finding that based on Pricker, the evidence at her disposal established the prima facie suspicion of money laundering. We know that she had no evidence even remotely suggesting that money laundering was at play. We also know that Pricker has nothing to do with money laundering. The legislation that establishes the offense of money laundering is poker, and you'll set it out there. And then in 140, he basically sets out the elements of the offense that I read to you in similar terms to what was contained in the president's affidavit that was served on the public protector. So go down. That's the offense that's listed in paragraph 40. And there's a second part of the offense in paragraph 41, right, which I've also taken you through earlier. Go down. Sets out the third offense, and we know that sections 4, 5, and 6 of the Poker Act. And then the court says the essence of the offense is the concealment of proceeds of crimes. Unless the money involved in the suspected money laundering transaction is the proceeds of crime, it does not matter how many accounts and transactions are involved in dealing with the money. There can be no offense of money laundering without the proceeds of crime. So that is the point that the High Court makes in its finding on the law, and which is confirmed by the Constitutional Court in its judgment, which confirms the High Court's findings. And that deals with the offense of money laundering under poker. That also deals with money laundering. And the other legislation that deals with money laundering, the court also deals with that, is the Financial Intelligence Center Act, the FIC Act. And it says that the FIC Act was introduced to combat money laundering activities and the financing of terrorist-related activities. The Act defines money laundering or money laundering activity to mean an activity which has or is likely to have the effect of concealing or disguising the nature, source, location, disposition, or movement of the proceeds of unlawful activities or any interest which anyone has in such proceeds, and includes any activity which constitutes an offense in terms of section 64 of this Act or section 4 or 5 or 6 of the Prevention Act. That's the Poker Act. All right. It then goes down that says there was no evidence before the public protector that any of the donations made to the CR17 campaign were the proceeds of crime, nor that the president entered into an agreement or an arrangement whereby he assisted Mr. Watson to conceal or disguise money which he knew or ought reasonably to have known is the proceeds of a crime. There was further no evidence before the public protector that the president knew or ought reasonably to have known that the Watson donation constituted the proceeds of unlawful activities. Additionally, it cannot be said that the president ought reasonably to have known that Mr. Watson made, and there is no evidence to suggest this, a tainted donation to his campaign and then failed to obtain information to confirm or disprove the fact. Go down. Clearly, the public protector had no foundation in fact and in law to arrive at the finding that the president had involved himself in illegal activities sufficient to evoke a suspicion of money laundering. In addition, the public protector based the finding on legislation that had nothing to do with the offense of money laundering. The conclusion is inescapable that in dealing with this issue, the public protector completely failed to properly analyze and understand the facts and evidence at their disposal. She also showed a complete lack of basic knowledge of the law and its application. She clearly did not acquaint herself with the relevant law that actually defines and establishes the offense of money laundering before making serious, unsubstantiated findings of money laundering against the duly elected head of state. Had she been diligent, she would not have arrived at the conclusion she did. Okay, so that's the part dealing with money laundering. There is a further affidavit that was before the court, which was done by the Financial Intelligence Center, which you find at page 601 of the affidavit. So go back to 31.7.5. Go to page 601. Paragraph 87. Just go up so that I can put the context to this. No, I just want to see what the heading is before that, so that we don't. I want to avoid any allegations that I'm misleading the committee. So the heading in the affidavit is the alleged money laundering. And the context behind this is that the public protector is perfectly entitled to go to the Financial Intelligence Center and put a request in for assistance, the ambit of which, for purposes of what I'm saying to you now, is not material. But she then gets a FIC report based on bank accounts, and we're going to come to that in a little while as to what was actually provided to her. But what the deponent from FIC says in his affidavit to the court is subsequent to the FIC report on 2 April 29, Miller, the analyst who compiled the report, addressed an email to the authorized office in the Office of the Public Protector, Mr. Rodney Mataboge. And in that email requested a meeting with him for the purposes of discussing the contents of the report. The meeting is a procedure that has been adopted by the FIC to ensure that the recipients of information it provides understand the process it adopted and the contents of the report, and he annexes the email. Go down. He then says the meeting convened on 10 April and present were Miller, Ace, Alberts, another representative of the FIC, and Mataboge. At that meeting, Mataboge specifically asked for confirmation on whether or not evidence of money laundering was found. No indication of money laundering, as he could not identify any predicate offense from which the money could have been proceeds of. I wish to emphasize that the FIC does not have investigative powers. It collects information, interprets, and analyzes it for the purposes of assisting the legislative entities who have such powers to conduct their own investigations. In this regard, the FIC's finding of the existence or not of the predicate offense are not conclusive, as it did not investigate whether or not such predicate offense existed. The conclusions were solely based on the fact that the amount of 500,000 came from sources that appeared to be lawful. Once the public protector had received the FIC report together with the source documents, she was duty-bound to conduct her own investigations and analysis as stated above. Right? Now, 30 March, when the public protector gave evidence, she confirmed to the committee that the wrong act was cited in the report. In that respect, I've now taken you to what she had told the High Court that informed the High Court's judgment in respect to the issue of Brecker. There are two other aspects that I want to point out in the record, because we endeavored to look from the record where Brecker came into issues with money laundering, and the only reference we could find was at page 1002. It is an interview which the public protector conducts with the attorneys from the EFG firm. For those who were not able to be with us last week, the EFG law firm up the trust bank account EFG2, into which the donation of 500,000 was paid into. We still have the Pusasa record. You just need to go to a different page number. 1002. Yeah. No, you're in the judgment. You're not in the record. 31.7.5. Right. So if we, there is an interview. If we go up, maybe just like with the heading. That's fine. This is the transcripts of the interview. Hold on, you can stop there. I just want the heading, which is now go up what is in the header of the document so that it can be identified. A little bit further up, stop. Right. This is the transcripts of the proceedings of the interview conducted with the directors of Edelstein, Faber and Grobler Incorporated on 23rd April 2019. And it is the first page of the interview where the public protector informs to identify who's in the interview, go down and sets out where go just past the introductions. Okay, stop there. The public protector and the public protector indicates to them in the sort of line 4 that we will indeed provide you with a recording after we have completed the investigation. I'm not interested in the recording, right? And then she says, if that can be understood, I will appreciate it. So it is prudent for us to emphasize that we are conducting this investigation in terms of Section 182 of the Constitution and in terms of the Prevention and Combating of Corrupt Activities Act. So clearly there was an understanding that the investigation was being conducted in terms of the Prevention of Combating and Combating of Corrupt Activities Act. At that stage, which was the date, that was the 23rd of April 2019. Only reference in the record that other than the affidavits that I have come to and the report in which it's mentioned, there may well be others, but those were the only two. So if you go, I've taken you to what the High Court had to say about it. And if we now go to the Constitutional Court judgment on it, in that regard, I want to go to paragraph 112 of the judgment, which you will see at bundle C number 3. And it would be, I think it's number 12. Yeah. Okay. And so we're going to go to paragraph 112. Public, yeah. So, as I said, I have not been dealing with the absence of facts, which both the High Court and the Constitutional Court identified as a defect. But in paragraph 12, it says the public protector once again must construe the empowering legislation. Then he says, the court says, the complaints to her were made in terms of Section 4 of the Members Act, which stipulates the complaint should relate to an alleged breach of the code. And I had prefaced to you what Section 3 and 4 of the EMEA Act had indicated to you. The code does not refer to money laundering, and yet the public protector treated the allegation as separate and dedicated a large portion of the report to addressing it and making a finding specifically on it. It appears that the public protector was aware that the Members Act did not empower to investigate the money laundering allegation, and she invoked the Prevention and Combating of Corrupt Activities Act, PCCA, with specific provision in a report. The public protector's report concludes its analysis of the PCCA by stating My investigation into the issue pertaining to possible money laundering is premised on the above legislation dealing with corruption and applies not only to private individuals who offer bribes, but also to private individuals who accept bribes. I would therefore have been remiss of me not to deal with this aspect of the complaint so as to be able to confirm or dispel with any suspicion as referred to in the allegation brought before me by the complainants. Go down. Having interpreted the PCCA, the Public Protector concluded that it criminalized corrupt activities and other forms of organized and financial crimes, including money laundering. But as the High Court rightly pointed out, and that's confirmation of the paragraphs that I've read to you earlier on, the PCCA does not create the crime of money laundering. Before us, Counsel for the Public Protector attempted to explain this as the innocent reference to the incorrect act. Right? So the explanation provided at the Constitutional Court by counsel acting for the Public Protector was to say that this was just an innocent reference to the incorrect act. The court then goes on and says there is no merit to the submission. The report quotes extensively from the provisions of the PCCA, which the Public Protector interpreted to be criminalizing financial crimes, including money laundering. This illustrates plainly that she misconstrued the PCCA. The report shows that she equated money laundering to corruption and bribery. Go to 115. Having investigated the money laundering allegations, the Public Protector decided to dispose of them in terms of Section 64C1 of the Public Protector Act. Once more, the Public Protector overlooked the fact that this provision is triggered where the facts disclose the commission of an offense during the course of dealing with a matter that properly falls within her competence. This disclosure must occur at any time before, during, or after an investigation of an issue listed in Section 6.4. Money laundering is not one of the matters listed in Section 6.4 as falling within the competence of the Public Protector. And apart from specified offences, crime is not reported to the Public Protector for investigation. And that is very important because it comes later when we deal with remedies and why the National Director of Public Prosecution sought to file an affidavit before the Concourt opposing the remedy relief that was sought. It says the Constitution empowers the police service to investigate crime. Yet here, and the Public Protector undertook to investigate an allegation on money laundering made by the leader of the official opposition. This differs from stumbling upon money laundering facts during an investigation. With regard to the allegation that the President and his family were involved in illegal activities that gave rise to the suspicion of money laundering, the High Court held that the finding lacked legal and factual foundation. This conclusion is unassailable. And before we leave the Concourt judgment, go to paragraph 194. And this is the judgment of the then Chief Justice Mkhwebane. Stop there. And I'm just taking you, and I'm not necessarily going to read to you all the paragraphs of the judgments of the all the paragraphs of the Chief Justice's judgment, because you've got that already. It was done extensively in some paragraphs more than once, and I think you'd be very irritated with me if I read you David and Goliath again. But let me take you to 194. The Public Protector relied on an incorrect legislation in dealing with the offence of money laundering in a report. Chief Justice agrees with the majority of the judgment that there was incorrect legislation relied on, and that's common cause. Where they differ is the reason that they put to the reliance on the incorrect legislation for money laundering. the Chief Justice says that does not really matter. She was not going to prefer criminal charges against the president. It is the police, in particularly the National Prosecuting Authorities, the drafters of the charge sheet or the indictment, if charges were to be referred, who had to ensure that the correct legislation was relied on. Hers was to alert them and ask them to investigate. So that's the view of the Chief Justice on that. Right. So through the one legal aspect being to that, I want to take you back to what did the president come to court to complain about when he came in the context and the founding affidavit, right? And so if we go although the president makes up his case in his founding affidavit, the public protector puts a very useful summary of what the president's case is at page 804, paragraph 95 of the affidavit. So we for the most part stay in section 35.1.7. I need to go out, but it will be quicker. 31.7, yeah, the record. Right. So the president relied on several grounds on which he challenged the public protector's report, including the one which I've just taken the committee through. Page number 804 is where I want to take you to first. Right. And this is, and I think this is about a fair summary which the public protector makes of the grounds on which, the main grounds on which the president relied. So let's take a summary of that to get an understanding of the president's case. Right. She says that the remedial action appropriates the functions of the National Assembly, public prosecutions, and the National Commission of Police Service, South African Police. That I lack jurisdiction to investigate funds paid to the CR17 campaign. That reliance was placed on an incorrect version of the Executive Ethics Code. That I violated his right to Section 58 of the Constitution. That the evidence does not support the findings made. That there is no duty imposed on him to disclose. That he was not given Audi. That the evidence was unlawfully obtained. Right. And then in paragraph 96, she says, I submit that the president has failed to establish a factual or legal basis for any of these grounds and the relief he seeks. None of these contentions are borne out by the facts of this investigation at all. Right. And they're all an attempt to obfuscate the matter, to take irrelevant technical points, merely avoid accountability. There is absolutely no legal basis for the contention that the president was entitled to more than what is contained in the Section 7.9 report, which included the possible adverse findings. Had I set out in greater detail any sanction, I would have been accused of prejudging the issue without hearing from the president. And in paragraph 97, she says, there's absolutely, now go down, I just want to make the principal point. There's absolutely no factual or legal basis for these contentions. I will address each of them in detail below for how two of these contentions can be dismissed immediately, and then she deals with two, which I don't want to come to right now. All right. He then in paragraph, go to page 840. So we the specific averments in the founding affidavit. I now tend to deal with the specific averments in the founding affidavit to the extent necessary. And she has above dealt with the president's broad challenges against my report. And she confirms I deny each and every ground upon which he had brought this application. So there's a complete denial that the president has a factual and legal basis for challenging the report. As we sit today here, we now know that the public protector has accepted that she had used the wrong act and that she had relied upon the wrong code. Right? And so that I don't misrepresent things, she will just go back up to the initial paragraphs of the public protector's affidavit, paragraph 2 or 3, so that we can put the factual and legal submissions into context. I think it's probably page click in 60 and see where it takes us. Further up, a little bit further up. Yeah. Go to paragraph 3, 2 and 3. She says the facts to which I depose are within my personal knowledge, and I accept where the context indicates otherwise, or I expressly say so to the best of my knowledge and believe both true and correct. And in paragraph 3, she says, where I make legal submissions, I do so on the advice of my legal representatives, which advice I believe to be correct. I also make of my understanding of the constitutional obligations of the public protector and those of Africa as a constitutional being. So she relies on her legal representatives and she relies on her own basis of understanding of what her obligations are and those of the president. We then turn to what the major findings were that the public protector made against the president. And I'll turn to the reference in a moment, but I just want to summarize the 3 or 4 major findings that she made. They include deliberately and inadvertently misled Parliament, that he had failed to disclose donations to the CR17 campaign, that her investigation supported the prima facie suspicion of money laundering. Those were the 3 major findings that the public protector had made, and it was against these findings that she issued certain remedial action. So if you go to paragraph 7 of the report, which would be at page 100, just go there. And you go to 7.1.4. Let's just start by 7.1. The way the public protector's report is structured, go up a little bit, we can see. Section 7 of her reports are generally where she deals with her findings, her conclusions, having dealt with the evidence in the above sections. Having considered the evidence uncovered during the investigation against the relevant regulatory framework, including the response to the Section 7I notice, and I make the following findings. And then she takes, you will recall that I read out the 3 headings that she identified as the issue, and she then sets out what her findings are in respect of the president. And I specifically want to take you to 7.1.4. You will see that there's a finding. I therefore find President Ramaphosa's conduct as referred to above, the representations that he made to Parliament, although ostensibly in good faith, to be inconsistent with his office as a member of cabinet and therefore in violation of section 96(1) of the Constitution as referred to above. Now, when the public protector deals with the president's submission, in the section 7.9 component of the report, which you find at paragraph 5.4.23. I think it starts at page 158. No, I might have the wrong page reference, sorry. Just go to 5.4.23. This is the paragraphs. So what the public protector has done is she has issued the president with a section 7.9 notice. And then in her report, she details his response in the paragraphs dealing with that complaint in her report. And this one deals with the paragraphs 122 to 145 of the section 7.9 notice relating to the allegations that the president did not mislead Parliament. Right? And she then says, the response incorrectly states as follows. The public protector has correctly found that the president acted in good faith. This is her paraphrasing or quoting from the president's submissions. That should be the end of the matter. Any suggestion that the president contravened the executive ethics code is incompatible with his own finding that his response to Mr. Mkhwebane was given honestly and in good faith. It goes further than that. It says the president in fact did not mislead Parliament at all. Mr. Mkhwebane told Parliament that he had proof that the payment was one Bosasa made to Andili. He was the one who misled Parliament, albeit that he did so innocently. And the response from the public protector in the next paragraph is, I have taken note of the preposterous argument advanced in this regard, and I do not agree therewith because nowhere in the section 7.9 notice did I make the purported finding. Following the rules of the National Assembly are very clear on the procedures to be followed during the question and answer sessions in Parliament. I have also dealt sufficiently with my reasons for the finding in this regard, and safe to say I do not agree with the arguments raised. I do not wish in the report, which I had canvassed at length in the section 7.9 notice. Now, the section 7.9 notice at page 86 D reached the conclusion that the president acted in good faith by saying the following. His conduct referred to above, although in good faith, is inconsistent with his office as a member of cabinet and therefore in violation of section 96(1) of the Constitution as referred to above. So we have a situation whereby in the context of section 96, the public protector has said he acted in good faith, and in the context of the executive ethics code, she has indicated that she has not said that they acted in good faith. And that's one of the issues that when we do ask the public protector to come before the committee, that should probably be cleared up. Right. So with that in the background, I want to take you to the rescission application, which you'll find in bundle D10. And we know that after the Constitutional Court dismissed the appeal on 23 July 2021, the public protector brought a rescission application. And in May 2022, the Constitutional Court unanimously ruled that the public protector's application for the rescission of its majority ruling, which confirmed the invalidation of the CRC by the Gauteng High Court in Pretoria, should be dismissed with cost, as no case had been made out for rescission. Now, I have checked. The Chief Justice Mkhwebane is not part of the bench that sits in respect of the rescission application. I think he by then retired, just so that there's no misrepresentation. of any kind as to who the court is that rules in respect of this. So if we go to bundle E10-4, the founding affidavit. Just go to page 23 first, and then we'll go up to the top. I want to see accept that she was bringing this application in paragraph 40. You will all be aware that seeking a rescission of a constitutional court judgment, even then, was a very novel step to take, and so the public protector set out the context in which she brought it in paragraph 44 by saying to the court, I wish to state from the very onset that as a person whose constitutional duties involves quasi-judicial adjudications, I am mindful of and particularly sensitive to the role that finality of judgments plays in the fabric of our constitutional democracy. The doctrine of res judicata is very fundamental to the smooth operation of the justice machinery. It assures the finality of court judgment and prevents matters from being relitigated on the same cause of action and between the same parties. And then she goes on to the law. Go up to the top of the affidavit, Chepo. Right, she identifies herself in paragraph 1. Paragraph 2. She says the facts contained in this affidavit are, unless the contrary appears from the context or is stated within my own knowledge, are not true and correct. Where I make submissions of a legal nature, I do so on the strength of my knowledge of the law and upon legal advice which my legal advisors have provided to me, which advice I accept to be both true and correct. She then, in paragraph 3 of, I'm the first applicant in the judgment handed down by this court on Thursday, 1st July 2021, attached hereto. In the aforesaid judgment, the court has committed a patent error, being an error which can be attributed to the court itself. Now, in the next section, she sets out who the parties are. So let's skip that. We don't envisage that to be necessary for this exercise. We then come to, well done, paragraph 12 and 13. She sets out what the purpose of the application is, and it's for rescission. And then we go down to 14. We seek alternative relief. And then paragraph 15, she says, she deals with the interpretation of legislation and the application of law. Now, just go down a little bit. I don't want to get into a debate about the law of rescission with this committee at the moment. So she sets out a brief background about the public protector. Go down, go to about paragraph 28, I think. I'm going to come back to some of those paragraphs in a bit. Right. Sorry, Shepo, let's go to, let's start at paragraph 28. And no, sorry, we're going to have to go up. Else the committee is not going to understand what the context is. Go down, go up to the start of that section. And then I'm going to be represented this to the committee. So let's just get, there we go. Start at 25. Right. So what she does in this application is she says that this court's patent error is that it applied the law as per the 2000 code and not the 2007 code. And it should have applied the code, the 2007 code, and by not having applied the 2007 code, it had committed a patent error. That's the patent error that she comes.
Just repeat that. I think you have mixed the years. Start again.
Sorry.
Just so
They
that
are-
we follow you properly.
There are two executive ethics codes that is referred to in this application. One is the 2000 code, which is the law, and the one is a 2007 code, right? The patent error that the public protector comes to to seek a rescission on is the fact that the Constitutional Court applied the 2000 code, which was the law. And the public protector says, you made a mistake. You should have applied the 2007 code because you made a patent error. And she sets out the reasons why they should have applied the 2007 code. And it's important for the committee to understand this, because this is what extensive evidence was led on last week.
So I was reading that heading there, so that's what maybe confused me, because it says this court approved their reliance on the 2007.
So the argument goes, and let me rather take it from the judgment, from her affidavit. So the argument made in the rescission application, and it's important that there is oral evidence before this committee and an acceptance by the public protector that actually the correct code is, and the lawful code is, the 2000 code. There was no doubt about that last week to do that. I'm taking you back in time to tell you what was her version before the Constitutional Court in the rescission application. And let me also say that there was an explanation given to the committee about the Nkandla judgment, which I'm also going to take you through in a moment, right? But let's start at the starting point of this. And let me also preface this. In the rescission application in the Constitutional Court was the first time this. I have scoured the affidavits of the public protector in the High Court and in the original affidavit for the application for leave to appeal to the Concord. So one of the questions that would be asked of the public protector is, where in those affidavits did you raise this issue? And I always accept that I could make a mistake, because I'm saying to the committee that I could not find a reference or reliance on this legal argument in the papers in the High Court or in the leave to appeal for the Concord. It arises for the first time that I have found in the rescission judgment. So that's a question that clarity needs to be obtained from her, or the committee needs to satisfy itself that I'm correct, that it's not mentioned in those two affidavits. It says, in the so-called Nkandla judgment, this Honorable Court unambiguously stated Advocate Thuli Madonsela concluded that the President violated the provisions of the Executive Members Ethics Act and the Executive Ethics Code. These are the national legislation and code of ethics contemplated in 96.1. Specifically, this Honorable Court cited Chapter 1 of the Ministerial Handbook, a handbook for members of the Executive and Presiding Officers, 7th February 2007. And then she points out the obvious and significant differences between the two versions are that the 2000 code was cautiously and deliberately framed, that's her view, to state only that members of the executive may not, A, willfully mislead the legislature to which they are accountable. And that's the dispute between the two versions, right? Plainly, this prohibition is narrow. As this Honorable Court correctly stated, members of the executive are forbidden from willfully misleading the legislature to which they are accountable. She quotes from that and then go down to 28. Then it says, abandoning its recognition of the 2007 code and Nkandla judgment, this court erroneously concluded that I, as the current public protector had seriously misconstrued the code. This was because the Honorable Court labored under the erroneous impression that I was using the old 2000 code as opposed to the later 2007 code approved and endorsed by the same Honorable Court. I was not called upon to construe or misconstrue the old 2000 code, but was legally required in accordance with the stare decisis doctrine to apply the 2007 code, whose applicability had been expressly endorsed by this Honorable Court in the Nkandla judgment. It was for this court to conclude and pronounce as follows. Quite clearly, the statement shows that she thought that the code prohibited members of the executive from furnishing any and every piece of incorrect information, regardless of their state of mind and the objective they wish to achieve. And then she says, both the majority and minority opinions did not question whether the and she's referring to the majority and minority decisions in the CR17 judgments, did not question whether the 2007 Code of Ethics that had been used by the Office of the Public Protector since at least 2009 is the applicable code instead of the superseded 2000 code relied upon by the extant judgment. This is an unprecedented and unconstitutional departure principle of stare decisis, which has been consistently upheld by this Honorable Court. The doctrine of precedent not only binds courts, but also binds courts of final jurisdiction to their own decisions. And it then says these courts can depart from a previous decision of their own, while they when satisfied that the decision is clearly wrong. Stare decisis is therefore not simply a matter of respect for courts of higher authority. It is a manifestation of the rule of law itself, which in turn is a founding value of our Constitution. It endangers certainty among the general public and other users of court judgments, such as the Office of the Public Protector. Public Protector recognizes in this paragraph the importance of the finality of court judgments. And I have no quibble with her views in respect of that. Paragraph 30, she then sets out why it's exceptional importance for the matter, because there are two divergent views approached by the same court. Go down. And both can't be correct. And then she says, a material, factual, or legal matter was overlooked in the decision, in that this court was either genuinely unaware that it had already accepted the Code of Ethics being used by the Public Protector as applicable law in the Nkandla judgment, or it departed from that judgment without expressly so pronouncing or giving reasons. And then in paragraph 32, and I'm going to come back to this paragraph because it becomes a very important paragraph as we proceed through the through this affidavit and the other affidavits. The Public Protector says, upon my appointment to the Office of the Public Protector, I duly familiarized myself with including the Nkandla judgment, the 2007 Code of Ethics, and also followed the precedent set by my predecessor, Advocate Thuli Maditsala. In accordance with the principle of stare decisis under sections 39 and 182 of the duty bound as the Public Protector to follow this court's Nkandla judgment in the interpretation of the applicable code. Had I acted differently, I would have been correctly criticized for not respecting the principles of continuity. Go further down. Paragraph 33, she says, accordingly, this application serves a narrow function to correct manifest errors of law in circumstances where this Honorable Court had patently made an honest error in its judgment or order. Further, at paragraph 48, page 26 of the decision application, I'm skipping the explanation given for that for the moment, and the legal framework that is set out. The Honorable Court further compounded its serious patent error when it ruled apparently unaware of the Code that the public protector dishonestly and incompetently changed the code and added words to it. Further, paragraph 49, the patent error committed can only be attributable to this court since the 2007 code became the only applicable law, was properly pleaded in the High Court papers and subsequently raised in the papers before the Honorable Court. I then go to paragraph 23, which you'll see on page 12. I think I skipped it. Apologies. Probably start by 16, Shepo, sorry. Yeah. The Office of the Public Protector had in previous years relied on, no, I didn't skip it, I had gone there. No, I have, Office of the Public Protector had in previous years relied upon various pieces of legislation in dealing with matters that involve the public office bearers, the Executive Members Ethics Act, and the Ministerial Handbook. Jane referred to as the, well, she defines it, and she attaches a copy of the former, and she only attaches the portions that contains extracts 2007 code, right? Go down. Right. The Members Act inter alia empowers the President of the Republic to draw up a code of ethics prescribing standards and rules aimed at promoting open and democratic government. Section 2 of the aforesaid code states, and then she sets that out. We have taken you through what the Executive Members Ethics Act says about the code, so I'm not going there, right? At paragraph 22, which is where I wanted to go. Says on 7th February 2007, then President Mbeki introduced significant changes to the Code of Ethics. He published the Handbook of Members 7th February, which was approved by Cabinet, right? And this is the genesis of this competing version of a 2007 code as it got put out. It says that the new code widened the prohibition considerably in that the new section 2.3 of the Executive Ethics Code now expressly states that members may not, A, deliberately or inadvertently mislead the President or the Premier, or as the case may be, the legislature. The difference between the 2000 and 2007 code for purposes of this committee is that the 2000 code says willfully mislead as opposed to deliberately or inadvertently, right? Mislead so I have not found, and we don't believe it to be common cause, but this 2007 code that found its way into the Ministerial Handbook was never proclaimed in a gazette, and it didn't comply with the requirements as set out in section 2.1 of the Executive Members Ethics Act, which I started off the address with. So it has no legal efficacy in the context of what this committee and what the courts had decided.
Okay, can we pause for 10 minutes tea break at that point? Thank you. We'll take a 10 minutes tea break, colleagues.
Recording stopped.
Welcome back, colleagues from T. Back on it, Alfred Bauer, over to you.
I just want to clarify the last proposition I put to the committee so that it's understood. When I talk about legal efficacy, I don't mean, I mean it in the following sense. There's an Executive Management Ethics Act. It is under that act that the code must be promulgated, and it is pursuant to that code that the public protector has certain has to ensure that that it's abided by, and it's the act makes provision that of how members must complain. So it's under that code, which emanates from that act, that the complaints of Mr. Shivambu and Mr. Mayamani comes before the public protector, right? And so when I say that that code must be promulgated, I have not come across anything that has shown a 2007 code to have been promulgated. That the only source or place that this 2007 code has been found is based on the affidavits as having been contained in the 2007 ministerial handbook. So in other words, what I'm saying is it can't be a code under the Executive Management Ethics Act because it doesn't fulfill the requirements of the Act, unless there's a gazette that I've not come across. So if we go to paragraph 21, page 10 of the rescission application. Yep. No. We were in the founding affidavit in the Constitutional Court. Page 10. So the affidavit then says, with regard to the provisions of the 2000 code, the Honorable Court correctly opined as follows in the case of Public Protector and others, the President of the Republic of South Africa. That is the judgment. Then it says, with reference to paragraph 55, it says, well, maybe just go a little bit further up. With regard to the provisions of the 2000 code, sorry, Shipper, go down, that's right. 55 says, when the former president drafted the code, he did not lose sight of the fact that members of the executive are usually called upon to give answers to questions raised in Parliament in respect of matters over which they have no personal knowledge. He cautiously and deliberately framed the code in these words. And then it sets out the words that we've already gone to in 23A. And then in 56, it says, plainly, this prohibition is narrow. Members of the executive are forbidden from willfully misleading the legislature to which they are accountable. In other words, for a member of the executive to breach the code, she or he must have given incorrect information with the intention to mislead the legislature. Incorrect information alone is not sufficient to constitute a violation of the code. Such information must be accompanied by a member's intention to mislead. And so I've taken you through 22 and then maybe go to 23. The 2007 code is then said to widen the scope of what the 2000 code provided. So based on what the public protector says in this affidavit, it begs the question as to what did the Nkandla judgment say and the stare decisis. The precedent set by Advocate Tuli Madansala and what has occurred in the office that that she refers to, right? So let's turn to look at that for a moment. And before doing that, I should probably clarify this in the way that it's been going before this committee. What is stare decisis? So that those who are not steeped in law can understand it. It's a Latin term that essentially means let the decision stand, or to stand by things decided. So in other words, there's a system of precedent holding that courts and judges should honor this precedent. And it means that when you consider judgments or your judgments of the own court, one does not depart from what is regarded as the ratio decidendi of a judge, of the judgment from prior cases or from prior cases. And having said that, I must then explain what the ratio decidendi means, right? It's also the Latin phrase, and it sort of says the rationale for the decision. In other words, you cannot depart from the rationale of the decision of a court. It is the point in a case that determines what the principle of the case establishes. And a good way to juxtapose that is where a court makes what we know as obiter dicta comments, or comments of observations made by the judge, which are not essential to the court judgment. Then those are not the rationale of the decision, but comments or observations in passing in a case, which do not require judgment and which do not create the system of decisions that stand. And so what the public protector then says is that we've created this stare decisis, which was caused by the Nkandla judgment. And Shepo, if you go to the Nkandla judgment, which is bundle C, PP judgments number 4, and we'll go to paragraph, the heading just above paragraph 7. Because the allegation in the founding affidavit before, in this rescission application, is that the CR17 Constitutional Court abandoned its recognition of the 2007 code in breach of the principle of stare decisis because of what is contained in paragraph 7 of the Nkandla judgment. In a nutshell, that's the, and last week that was dealt with. It's number 4 of the PP judgments in other judgments, yeah.
Chairperson.
Oh, thank you. Honorable Olomisa, you have your hand up.
Yes, sorry, man. I raised my hand on a point of order because I sense, or rather I hear the presentation by the evidence leader as part of a legal argument when the witness has finalized her presentation and the parties, I mean the members of parliament have asked questions to the public protector. And then later, the legal fraternity representing or legal advice team representing the public protector as well as evidence leaders, they can now engage in what the evidence leader is doing right now. If we want to be briefed further, we need to get, if anyone has got no facts, the minutes are there. What is she trying to do? Unless we're in a PR exercise here, I'm lost, completely lost. This is a legal argument you will get when the two legal teams are closing. We have not even asked questions to the public protector. No, this is unfair.
Thank you, Honorable Olomisa, for the concern you're raising. Unfortunately, I must say that firstly, what is being done are not legal arguments. We're still going to go into legal arguments when everything else is done. I think
Thank you. You've answered me.
Okay, Mkhulu. All I wanted to say was that, yes, we have covered that ground. So maybe a little bit of patience for us to go through this and listen to it and apply our minds on it. Thank you. Proceed, Advocate Bauer.
Chair, what I'm dealing with is the contents of the public protector's affidavits. And we are dealing with court judgments, but in the context of the affidavits, because the motion deals with court judgments. So it does sound like I'm arguing the interpretation of law, but what I'm trying to set out is essentially what the judgments say.
Honorable Misa is answered. Thank you.
So if we go to the paragraph go up to the heading. Yeah, it's 1 or 2 paragraphs up. Stop. Right. So what the judgment does is it sets a background. And in paragraph 5, it identifies who have lodged complaints. And then in paragraph 6, it sets out what the public protector concluded. And in paragraph 7, it says, in reasoning her way to the findings, the public protector said that the president acted in breach of his constitutional obligations in terms of section 96(1), 2B, and C of the Constitution. So what one sees from the judgment is a recordal of the reasoning of the public protector in that regard. And then if you go down, in paragraph 7, after the quote, in the same breath, she concluded, being the public protector, that the president violated the provisions of the Executive Members Ethics Act and the Executive Members Ethics Code. These are the national legislation and code of ethics contemplated in 96(1). Right. And so if you go to the footnote, you'll see that what is referred to in the footnote is chapter A. One finds no other reference in the Nkandla judgment to the code. And so when we argue the matter, and we will do legal argument, which will come later, just to preface that so that there's an understanding of it, what we will argue is that there was a misunderstanding about what stare decisis was, and that there was no express affirmation or acceptance that the 2007 code had been the correct code. But that will be with reference to case law when we argue that matter. But if you go to paragraph, go back to the affidavit in, sorry, Shepherd, don't go out of the affidavit, just hold on. There's one further issue I want to raise in the affidavit. So let's just go down to, it's footnote 35. So you just have to scroll down a little bit, because it deals with this challenge to section 96. One of the challenges which you would see that was raised was that it was an infringement of section 96 of the Constitution, and just the Chief Justice deals with that. There was an argument, as you see at the top of paragraph 25, beginning with the president. The EFF argued that he breached obligations in terms of section 83, 96, 81, and 182 of the Constitution. And there is a footnote because the source of the Executive Ethics Act code comes from section 96. And so what Chief Justice Mkhwebane says is section 96 bears no relevance to the core issues before this court. Admittedly, it is pivotal to the public protector's findings that although the president was aware of the erection of non-security upgrades at his private residence, he is not known to have done anything to discourage the construction or to put an end to them, considering his fiduciary duty to the state. And then after the quote of the judgment, it says, but this application is not about determining whether the president and his family benefited unlawful from non-security installations or upgrades. That was for the public protector to do, and she had already done that. The focus of this application is, go further down. On the implementation of the remedial action taken by the public protector. And Section 96 can in no way assist on the process meant to secure the president's compliance. It cannot therefore be a justifiable basis for conferring exclusive jurisdiction to this court. He does go on in the order, and the court makes no finding in respect of any infringement on Section 96 of the Constitution. I was going to take you back to what the public protector says in her affidavit. In paragraph 25, page 14. So we go back to number 4, founding affidavit. Page 14. 25. Right. And that was where it says, in the so-called Nkandla judgment, this honorable court unambiguously stated that my predecessor, Advocate Thuli Madonsela, concluded that the president violated the provisions of the Executive Members Ethics Act and the Executive Ethics Code. These are the national legislation and the Code of Ethics contemplated in 96.1. Specifically, this honorable court cited Chapter 1. We will deal with argument in respect of that. I'm simply highlighting to you what she says on affidavit, and I've shown you what the judgment says. Go to paragraph 59, 29, sorry. Both the majority and minority opinions did not question whether the 2007 Code of Ethics that has been used by the Office of the Public Protector since at least 2009 is the applicable code instead of the superseded 2000 code relied upon by the extant judgment. This is an unprecedented and unconstitutional departure from the well-established principle of stare decisis, which has been consistently held by this court. So you can see there where it comes from, the Nkandla judgment, right? At all. Okay, so that was the one issue in the affidavit. And we know that the CR17 case, what it was not about profiting from state resources. And I indicated to you, and I've raised this because this was raised for the first time in the context of the rescission judgment, as far as I've been able to ascertain. The second aspect goes back to where the public protector says that she duly familiarized herself with the court judgments, including the Nkandla judgment, etc., which was in paragraph 72, to do that. And where she says she's duly followed the 2007 code. And for that, I want to take you to page 47 of the public protector's report at paragraph 5.1.19. 47, public protector's report. Paragraph 2.3 of the Executive Ethics Codes further state that members of the executive may not willfully mislead the legislature. You will see, as we've indicated, that that is a quotation of the 2000 code. Right? And if you go to the record 31.7.5, public protector's affidavit at page 820, under the heading of the Executive Ethics Code. Let's just take it from 127. The President alleges that I made use of a draft version of the Executive Ethics Code, and that therefore the entire investigation was influenced by a material error of law, and that the correct version of the code states that the members may not willfully mislead the legislature, whereas the version I allegedly relied on states that members may not deliberately or inadvertently mislead the legislature. Go down. He further alleges that although in some parts of the report reference is made to the correct wording of the code, and that these references compound the scale of confusion and irrationality of the report. Then she says in paragraph 129, I admit that the correct version of the code appears at paragraph 5.1.19 of the report, which provides that the member may not willfully mislead the legislature. I admit that in certain sections of the report, reference is made to a different version of the code, which provides that the member may not deliberately or inadvertently mislead the legislature. The ministerial handbook also refers to the version of the code, which provides that the member may not deliberately or inadvertently mislead the legislature. Go down to paragraph 130, because there's the explanation that's provided to the High Court. I submit that the error in inverted commas is immaterial in light of the fact that my finding is based primarily on the President deliberately misleading Parliament rather than inadvertently doing so. Go down. Whether the President willfully misled Parliament or deliberately did so is one and the same thing. There is absolutely no basis for the claim made by the President in this regard. What is concerning is that the President raises all sorts of technical issues but fails to address the facts. Now, what we will address the committee when we do deal with legal argument is the judgment of Harris in the Constitutional Court, which deals with when you rely on the wrong provision of law and when you make decisions, because that's the argument of relevance to this court in that to this committee in that regard. So that brings us to the issue of the 2000 Ethics Code, which is promulgated, we know, in Government Notice 41 on 28 July 2000. And if you click on page 418, yeah, you will see that the Government Gazette containing the 2000 Ethics Code is attached to the founding papers marked MCR 22. Right. So that takes us to the CR 17 report. What did the public protector actually say in the CR 17 report, which the President highlighted? Shepherd, just go to the report. Your members will recall that I took Mr. Mataboge through the section 7.9 notice that was finalized. I didn't take him through a draft. I took him through the final version to show the inconsistencies within the section 7.9 notice. I want you to go to page 15 of the report first. This is part of the summary of the report, which encapsulates the findings of the public protector in that. Go to double C. The conclusion reached, go down, is that consequently, President Ramaphosa's reply was in breach of the provisions of paragraph 2.3a of the Executive Ethics Code, the standard of which includes deliberate and inadvertent misleading of the legislature. Right, so that's the first one, deliberate and inadvertent misleading as a standard. Then we go to paragraph 2.3.3 on page 20. Go down. 2.3.3. There we go. Sorry, check. We have paragraph 2.3 of the Executive Ethics Codes further state that members of the executive may not willfully mislead the legislature. So here we have the correct 2000 version, right? Then if you go to page 47, that is the one I took you to earlier, which also reflects the correct version of the Executive Ethics Code. Right? So if you look at that in that order, so that's now twice we have the correct 2000 version. Now if you go to page 50, which is paragraph 5.1.34. Stop there. When it's paraphrased, consequently, President Ramaphosa's reply was in breach of the provisions of 2.3a of the Executive Ethics Code, the standards of which include deliberate and inadvertent misleading of the legislature. He inadvertently or deliberately misled Parliament in that he should have allowed himself sufficient time to consider the question and make a I'm reading on to the next page, informed response. So now we see it as being inadvertently and or deliberately. Is then a version at page 57. .2.8. Right. We see again, it's may not willfully mislead the legislature. So we've got the correct version in 5.2.8. Then if you go to 5.1.3, where are we now, 57, page 99. Yeah. 6.3. That's under the heading of observations. We see that in the last line it says they would have been regarded to have misled the House inadvertently or deliberately, right? So there it's used again in a different context of EMEA, which isn't actually a quote on section 2.3, so that I'm not misleading you in saying that. Let's go to paragraph 7.1.3 on page 100, which is the findings. Consequently, President Ramaphosa's reply was in breach of the provisions of paragraph 2.3a of the Executive Ethics Code, the standards of which includes deliberate and inadvertent misleading of the legislature. So what does this show us? It shows us that every time paragraph 2.3a of the code was cited in the report, it referred to the 2000 code. And that is a perpetuation of what was in the 7.9 notice, which we took Mr. Mataboge through. What we don't have attached to the Rule 53 is a version of the 2000 code. We have a version of the ministerial handbook, but legislation doesn't have to be included in the Rule 53 record, so that isn't really an issue. Right, so what does the president say in his founding and supplementary affidavits in respect of this? He says, and you need to go to paragraph 122, go to the 3175 founding affidavit. Sorry, you have to go up to the top, just take it to the beginning of the document. seem to have misplaced the number. See if I can get it for you quickly. This one doesn't have a number to it. It's paragraph 122. Just go down. The finding affidavit's one of the first in the document. Just page 48. So we started on the top. This is the section of the affidavits that deal with a material error of law that the public protector misread the code. And basically says, I'm advised that the functionary in the position of the public protector must not only get the facts right, she must also get the law right. This is a fundamental requirement of the principle of legality. If the findings of fact and conclusions of law are based on an inaccurate understanding of fact and a gross misunderstanding of the law, the outcomes can be no rational relationship to the facts presented. In this particular instance, the public protector has displayed a grave misunderstanding of the provisions of the code. In paragraph 5.1.2, the public protector stated the following. However, in the absence of such explicit rules dealing with such corrections or amendments, regard must be had to section 2.3 of the code, which states that members may not deliberately or inadvertently mislead the president or the premier, or as in this case may be the legislature. I'm advised that this statement, which appears to have been the basis of the finding that I misled the National Assembly, is based on a misreading of the code. I have noted above that the code states that the member may not willfully mislead the legislature. It is not clear where the public protector extracted the contents of paragraph 5.1.82, as it is not clearly referenced in the paragraph. Bearing in mind that the public protector proceeded from an incorrect premise, it was inevitable that she would reach equally irrational findings. Then he goes on in paragraph paragraph 128, the incorrect understanding of the code has plainly permeated the reasoning process of the public protector, producing a flawed outcome. So that's what the president says in page 48 from paragraphs, paragraph 129, he says further, I know that in some parts of the report, there are references to the correct wording of the code, but I submit with respect that those references compound the scale of the confusion and irrationality of the report. They illustrate that the public protector lacks understanding of the code that she must enforce, or alternatively is confused about the legal standard that is applicable. Neither scenario conduces for rational outcomes, which are in keeping with the principle of legality. In paragraph 30, he concludes, I submit therefore that the fundamental error of law of misreading the code has materially affected the reasoning process, producing an equally flawed and irrational outcome. On this basis alone, I submit that the entire finding concerning the statement that I made in Parliament on 6 November 2018 must be set aside. That's the president's case, and he annexes a copy of the 2000 code. In the text of the public protector's High Court answering affidavit before the court, she states the following, and we go to page 820. So this is where she deals with the executive she responds to what the president has to say and says, in this regard, the president alleges that I made use of a draft version of the Executive Ethics Code and that therefore the entire investigation was influenced by material error of law, and that the correct version of the code states that members may not willfully mislead the legislature whereas the version I allegedly relied on states that members may not deliberately or inadvertently mislead the legislature. I had taken the committee through these paragraphs. In paragraph 129, where she makes the admission and where she then says it matters not what the error is. She then goes and she deals with paragraph 196 with the relevant paragraphs of the president's submission in the where she answers them paragraph by paragraph. 196. And she says the contents of these paragraphs have already been dealt with elsewhere in the affidavit. And we've just taken you through paragraphs 122 through to 130, 130 that deals with these provisions or these sections. I admit that the correct version of the code appears at paragraphs 519 of the report, and that certain sections of the report reference is made to a different version of the code, which provides that the member may not deliberately or inadvertently mislead the legislature, and she accepts that. And then in 196.3, she says, I submit that the error is immaterial in light of the fact that the finding I made was President Ramaphosa deliberately misled Parliament, save as a force that the allegations contained herein are denied. So effectively, she denies, she admits that she got the code wrong, and she says that actually what I did is immaterial, and it's not a material error of law because she denies the allegations in the president's affidavit. The president in his reply acknowledges the admission that she makes and that she admits to getting it wrong. And he so we know that that's what she says and what she's admitted. And the president, sorry, my apologies, I've missed a reference. If you go to his reply at 1249. Go down to paragraph 51, I think. Under the heading, she got the code wrong. One of the grounds of review is that the public protector made a material error of law in that she misread the executive ethics code and she applied incorrect principles. And I found that I had breached the code in that I had inadvertently and or deliberately misled the National Assembly. I amplified this ground after I received the record to point out that the public protector had misread the code. Public protector admits her error, and he details what she says, and which I've taken the committee to. And then she accepts what the correct version of the code is. And then it says further, if that explanation, there's nothing to suggest that just because the word inadvertently is not used in paragraph 5.1.19, it must be referring to the correct version of the code. Only the incorrect version of the code was included in the record, and there's no explanation by the public protector as to why, if it featured at all, the correct version of the code was not included in the record. Go down. I've already indicated that the issue of the legislation. A random reference in the middle of the report is of no help when the actual finding refers to both inadvertent and deliberate misleading of the National Assembly. My conduct could not have been deliberate and inadvertent at the same time. Then he says, the public protector further tries to mitigate a danger by pointing out that the ministerial handbook also refers to the version of the code which provides that the member may not deliberately or inadvertently mislead the legislature. Respectfully, this case is about the executive ethics code. It is not about the ministerial handbook. If that handbook contains an error, it does not justify the perpetuation of that error by the public protector. As if that is not enough, the public protector goes further to claim that the error is immaterial in the light of the fact that my finding is based primarily on the president deliberately misleading Parliament rather than inadvertently doing so. This smacks of desperation and cannot possibly be true. The public protector's finding is set out in paragraph 7.1 of the report. It has 4 subparagraphs that alternate between the theme of deliberate misleading and inadvertently misleading Parliament. And then he sets it out. Paragraph 7.1.1 speaks of deliberately misleading the National Assembly. Paragraph 7.1.2 does not use the words deliberately or inadvertently, but refers to my answer as being, albeit defective in terms of the rules of the National Assembly, was misleading. Paragraph 7.1.3 says my reply was in breach of provisions of paragraph 2.3a of the Executive Ethics Code, the standard of which includes deliberate and inadvertent misleading of the legislature. And paragraph 7.1.4 speaks of my conduct having been in good faith, but in violation of section 96(1) of the Constitution. Respectfully, conduct cannot be in good faith and be deliberately misleading at the same time. Paragraph 56, he says, however, therefore, to reach the conclusion that the error does not matter because the public protector primarily found me guilty of deliberately misleading the National Assembly, one would have to reach selected excerpts identified by the public protector instead of reading the report as a whole. That would be irrational. However, the irrationality does not only lie in reliance on the alleged inadvertent and deliberate misleading of the National Assembly at the same time. The public protector is all over the place in the report and are answering affidavit as to whether she's referring to the Executive Ethics Code or the Code of Ethical Conduct and Disclosure of Members' Interest for Assembly and Permanent Council members. The finding in paragraph 7.1 that I misled the National Assembly is clearly based on both, despite the fact that at the time in question, I was the President of the Republic and therefore not a member of the National Assembly, and therefore the Members' Ethics Code could not have been applicable. All of this notwithstanding, the flippancy of the public protector to this very serious issue demonstrates a frightening level of callous superficiality. She has found me guilty of violating section 96 of the Constitution. Before making such a serious finding, she should have taken care to get the law and the facts right. The public protector is disingenuous in referring to a fundamental misunderstanding of law as just an error. She relied on the incorrect version of the code in her report dated 5 July 2019 against Minister Pravin Gordhan while he was still the SARS Commissioner. I attach marked RA2 only page 39 of that report and refer the court to paragraph 5.111 where the public protector recorded paragraph 2.3a of the Executive Ethics Code, which provides that members of the executive may not intentionally or inadvertently mislead the president. If there is a dispute about the reference quoted, the entire report will be made available at the date of the hearing. Chair, I want to go next to the affidavit in the SARS unit matter. And may this be a convenient time to adjourn, because that would just, it's 5 o'clock and it would just take me a bit over in finalizing that.
We're going nowhere. You can go ahead. No, thank you. That's a joke. I know it's a month of Ramadan, so a lot of energy there. It's 5 o'clock, colleagues. That's the time for our program to end, and for us to adjourn the meeting for the day. We will reconvene tomorrow at 10 to proceed with our work. In the meantime, as I indicated in the morning, work is continuing on the other front of ensuring that we properly mitigate that risk of the legal fees. As progress is being made and an outcome is readily available, we will indicate so. But for now, we adjourn for the day. Thank you very much. The meeting is adjourned.